All right, the 152nd, now in session, the Honorable Bob Schaffer presiding.
Thank you. Everybody have a seat, please. All right, we're now calling cause number 17010811977, Carson Gray versus Edison Automobile Company. Well, I'd like the parties to please announce their appearance and whether they're ready to proceed, starting with the plaintiff.
Good afternoon, Your Honor. Jeff Krumpholz for Plaintiff Carson Gray,
And Paige Lawrence for Plaintiff Carson Gray.
and we are ready to proceed to opening, subject to some housekeeping and MIL, Judge.
Thank you.
Good afternoon. For the defense, my name is Hayleigh Nuenke, Nuenke, together with my co-counsel Gracie Mahoney, Mahoney, and we are ready to proceed to opening statements pursuant to some housekeeping matters and a motion amendment in two parts.
Okay. Mr. Wilson?
Yes, Your Honor. As far as housekeeping, may we assume that all witnesses who take the stand have been pre-sworn?
Yes.
And may we assume that all exhibits are pre-marked according to the joint exhibit list?
Yes.
And then, Judge, if we ask to approach, may we do so constructively so that the jurors can hear our conversation?
I'm not sure the jurors want to hear your conversation, but we can constructively approach the bench.
Fair enough, Judge. Thank you.
And then we request a 5-minute recess at the conclusion of the plaintiff's case in chief.
We'll see how the timing is going, but I suspect we will take a recess at the end of the plaintiff's case in chief.
Thank you very much.
Anything else?
No.
Okay. Who's doing opening for the plaintiff?
Me, Your Honor. Jeff Krumpholz.
I think I just called you Mr. Wilson, didn't I?
It's okay, Your Honor. It's a compliment in these parts.
I checked the wrong name here. And you are,
Paige Lawrence, Your Honor.
that's okay, that one I checked correctly. Okay, and who's doing opening for the defendant?
I will be. Your Honor.
Okay, are these rounds being timed? Okay, and y'all have your timekeepers established?
Yes.
I'll be keeping time for the round.
Don't scare the court like that.
I apologize.
Be respectful of what's going on in this courtroom. Don't just barge in like you own the place.
I apologize, Judge Schaffer. I'll be keeping time for this.
Okay, thank you very much. Okay, Mr. Krumpholz, you may proceed. Everybody else can have a seat.
Your Honor, my co-counsel Paige Lawrence is going to present at this time. That's right.
Go ahead.
Your Honor, plaintiff does have one motion to eliminate, but we've stipulated during pre-conference that defense is not going to bring this in. It's a DUI charge that our plaintiff Carson Gray had, and just want to.
You have a stipulation amongst the parties, among the
We
parties?
discussed during pre-conference that any testimony regarding Mr. Gray's former DUI will not come in today.
Okay, that's fine. Anything else?
No, Your Honor.
Anything from the defendant?
Yes, we have a motion named two parts. This case is about a reckless driver that pulled in front of an automated vehicle causing a collision. And we anticipate that the plaintiff will try to bring up a separate incident that has no relevance in this case called Superloop. It's a different company and has no relevance. Your Honor, we do plan to get into testimony regarding this Hyperloop incident. While they aren't the same company, they do have the same CEO, Keaton Sent, who we're going to hear from today, who is not only the CEO of both companies, but the lead engineer of both companies. He's very involved in both projects. We will be presenting this testimony to show that Keaton Sent was aware that has a history of showing that of his technology being faulty and looking the other way, doing nothing about it. And therefore, that's why we.
Okay, the court grants the motion. It doesn't preclude you from going into it. It only means you have to approach the bench prior to going into that, and then we'll make the ruling on whether on the evidentiary matter, whether that comes in or not.
Yes, Your Honor.
Anything else?
Yes, we have one more. We anticipate that the plaintiff will try to get into another incident that occurred, and this is a weather-related incident that occurred with these cars. And once again, relevance, it was weather-related and has nothing to do with the operating system of this vehicle. Your Honor, this incident that opposing counsel is referring to is the same company, the same CEO, same technology. One of their
Liver Vehicles, which is like a rideshare vehicle that has been partnered with Edison as a driverless vehicle. One of those vehicles veered off the road in one of the test cities that these Liver Edison vehicles are in, and therefore it's extremely relevant to our case today to show that Mr. Sin and Edison vehicles were put on notice that these vehicles were having problems and didn't do anything about it.
Was the other company? The vehicle was owned by not the defendant here, but the other company.
Same company, Your Honor.
The vehicle's owned by Edison?
Edison vehicles, yes.
Okay. I'll grant the motion again. Approach the bench prior to bringing it up during the trial.
Yes, Your Honor.
Anything else?
No, we are ready to proceed to opening statements.
Thank you. Anything else?
Ready to proceed, Your Honor.
Okay, let's move on. Opening statements, please.
Thank you, Your Honor. May I proceed?
You may.
May it please the court. Opposing counsel. Members of the jury. A sum total of nothing. This case is about a tech company who ignored problems with its technology, and they put a dangerous vehicle on the road, and this young man paid the price. By way of introduction, my name is Jeff Krumpholz. My co-counsel, Paige Lawrence, and I represent this young man, Carson Gray. He's the plaintiff in today's matter. You see, Edison Automotive Company should have never put this car on the road. They should have never allowed the public to be placed at risk. And this car should have never had the opportunity to injure Mr. Gray. Now, Carson Gray is a 34-year-old man, and he has one passion and one passion only. He loves motorcycles. In the morning, he gets up, he puts on his work clothes, he goes to his job, and he thinks about motorcycles the whole rest of the day. He gets off work around 5. He loves motorcycles. So let me take you to 2017. 2017 is the year that Carson was able to purchase his first motorcycle. He bought the motorcycle in January of 2017. There was a little glitch. Carson, although he had done all the safety training and had all the experience as a rider from years before, he didn't have his motorcycle license yet. So what does he do? He lets his friend Vince hang on to the motorcycle. There you go, Vince. You can drive a motorcycle. When I get my license, you can give it back. Pretty simple. So on a sunny day in September of 2017, Carson is going to meet up with Vince at Montana Max's. We all know Montana Max's, it's here in town. So Carson walks from work and Vince pulls up on Carson's motorcycle at Montana Max's. So far, so good. Vince parks Carson's motorcycle right alongside the curb like this in a parking space. Here in front of the parking space is a Liver pickup zone. Liver, as we know, is a rideshare service. You can get a ride, you go on the app, the car comes and takes you where you want to go. Pickup zone in front of where Vince parks Carson's motorcycle. Everybody's still good up till now. Carson naturally wants to sit on his motorcycle. It's been at Vince's house. Carson hasn't been able to ride it at all because he doesn't have a license. He knows he can't ride it without one. So Vince hops off the motorcycle and Carson hops on the motorcycle. Now the motorcycle is still parked. The motorcycle is running, but it's not going anywhere. If you think of a motorcycle like a manual shift car, when your manual shift car is in neutral and stopped, it's not going anywhere until you put it in gear and hit the gas. So this motorcycle, the engine running, is in neutral, it's parked. Carson hops on it. He fills the engine. You may want to rev it a little bit because remember, you give it gas, it's not going anywhere. It's parked. It's his motorcycle, that's his baby. So while he's sitting there, and up till now, everybody's still okay. While he's sitting there, Vince, who's standing next to Carson, says, "Hey, is that one of those driverless Liver vehicles coming down the road?" So Carson turns over his shoulder to look back at the road. This is Webster Street right here over Carson's shoulder. So he looks back and he sees that driverless LIBOR vehicle coming to the LIBOR zone, allegedly. Now, here's where Edison comes in. LIBOR is partnered with Edison. Edison makes the driverless cars. LIBOR can now use them to go pick up passengers. Well, that's all good, except Carson notices two problems. One, that car, instead of going around him to the zone where it's supposed to go, that car is coming straight for him as if he wasn't even there. That's the first problem. Second problem. Carson sees that that car is not slowing down. The next thing he remembers is waking up in the hospital. Now, I want to pause right there. We're going to come back to Carson in the hospital. And I want to take you to Edison for a moment. What's Edison's part of this? Did they just make, design, build, test the car? No, there's more. You see, 5 months before Carson was hit, an engineer sends an email to the CEO of Edison. The CEO sitting right here, Ms. Keaton. And the engineer says, hey, there's a problem with our technology. It's bumping into bicycles and stuff. I think we need to take a look at this. The CEO says, 3 hours later, that's nothing. I looked at the tapes, no issue. We're going to show you evidence of that email exchange. We're going to show you how in a response, this engineer says, no. We need to shut this program down now. Public safety issue. CEO says, you know what? Have you been drinking again? So a safety issue is brought to the attention of the CEO. And he looks at the time of the email and asks, have you been drinking again? So that's 5 months before he gets run over by that technology. Because, ladies and gentlemen of the jury, these cars can't see bicycles, they can't see motorcycles. There's a problem with the technology. If you have 2 wheels, this car has a hard time picking you up. It can't see you. Briefly, I will mention 3 years before that. In a simulation, one of Edison's cars hits a parked bicycle in a virtual simulation. This company knew. And they did a sum total of nothing. Now we have to present our case to you. And basically at the end, we're going to ask you to weigh this out. Which is more likely? Story we're going to tell you today and have witnesses present to you under oath with evidence backed up by facts? Or are you going to believe a smokescreen that's going to come from Edison about how they're not responsible? This kid, it's his fault. We have to prove this is more likely than theirs. So finally, I want to take you back to the hospital. Carson wakes up, dazed and confused, doesn't know anybody. He spends 2 weeks in the hospital. He has a significant head injury, significant. He has 2 shattered legs. The hardest bone to break in the body is the femur. He had 2 broken ones. It took him 6 months to learn how to walk again, and he still walks with a limp. He still feels significant pain today. We're going to bring you that evidence, members of the jury. We're going to ask you to do the one thing that justice requires in this situation. It's a very simple thing. Just make it right. Hold Edison responsible for this young man's $125,000 in medical expenses. For this young man's lifestyle changes he's had to undergo as a result of this traumatic event. Make it right. For the fact that they did a sum total of nothing.
Thank you. Ms. Nuenke, would you wish to make an opening statement at this time?
Yes, Your Honor.
You may proceed.
May I please the court? The simple answer is usually the correct answer. And you're going to see that that is exactly the case here today. what's more likely? That a highly autonomous vehicle with multiple detection systems backed by years of testing and research spontaneously failed in a way that it never had before? Or is it more likely that Carson Gray had a momentary lapse in judgment and he decided to pull his motorcycle out into traffic without looking, and a collision occurred that was unavoidable? My name is Hayleigh Nuenke, and together with my co-counsel, we'll be representing the defense at an automobile company. Now, we're here today to talk about an accident that occurred on September 4th, 2017. So let's go back to that day. On that day, Edison had vehicles out in operation in the city of Steelton. They were in a partnership with a rideshare service called Liber. And one of those vehicles was on its way to pick up a passenger in front of a local bar called Montana Max's. Now, you're going to hear a lot about these vehicles today. The owner of Edison, Ms. Keaton Sent, is here today, and she will tell you about all the research, prototyping, everything that went in since 2010 to get these vehicles to where they are today. Ms. Sent will tell you that for 5 years, before these vehicles ever were out on the roads, that they were tested virtually. And she will tell you that once she put them on the roads, that she put not one, but 2 engineers in control of those vehicles to make sure that they were operating safely. And then she will tell you that she did not put these vehicles into driverless operation until they had gone 13 months without a single incident, and they were approved by every single regulatory agency. And you will also find out that on the day of this incident, that it has been 6 months of flawless driving by these driverless vehicles. And then you will find out about how these cars work. Ms. Keaton Sent will tell you that that car that was on the road that day, it had a radar system. And that radar system was used for detection of other cars. That car had video cameras, once again, used for the detection of other vehicles on the road. And that car had an advanced LiDAR system that used light to, again, find other vehicles on the road. 3 separate systems, all used for locating other cars on the road. And now, Edison is a big company, and Ms. Sent is a well-known woman. And with that come opinions. Some of you may even already have an opinion on Ms. Sent. But I want you to remember that we're not here to talk about Ms. Sent today. We are here to determine one simple question, and that is whether or not this collision was caused by Edison's negligence. Like I just said, this case is about negligence. So the plaintiff is going to try to tell you things that they think Edison did and didn't do. But I want you to listen very carefully today and listen for all the things that Carson Gray did and didn't do. Carson Gray will testify today, and he will tell you that on September 4th, 2017, he was on his way to Montana Max's. He was meeting his friend Vince. Now, Vince was keeping his motorcycle because Carson had failed his motorcycle exam. He had failed that exam by just 1 single point. And he was retaking that exam the very next day. He will tell you that he arrived at Montana Max's, waited for Vince to arrive, and Vince arrived riding his motorcycle. Carson decided that he wanted to go ahead and get on that motorcycle. He sat on that motorcycle with the engine rumbling beneath him, and he's going to tell you that he had no intention of riding it. He's going to tell you that he was sitting on that motorcycle, dreaming of the open road simply for motivation. And then you're going to hear that a collision occurred. You're going to hear that a collision occurred between this highly advanced autonomous vehicle and the unlicensed Carson Gray. And you're going to have to ask yourself, which version of events is more likely? Is it more likely that the radar system failed, that the video cameras failed, that the LiDAR system failed, that none of these detection systems saw Carson Gray and avoided this collision? Or is it more likely that Carson Gray, excited about his exam the next day, thought, what would be the harm in going out for a quick ride? So he pulled out into traffic, the LiDAR was coming, and there was no time to stop, and a collision occurred. Now, the plaintiff holds the burden of proof in this case. They must try to prove to you that this collision was caused by Edison's negligence. And I ask that you hold them to that burden. because I am confident that they will not be able to meet it. I am confident that the evidence will show that this collision had nothing to do with Edison. And I am confident that at the end of this trial, you will come to the only conclusion that the evidence supports and justice demands, and find that Edison is not liable. Thank you.
Thank you. Call your first witness, please.
Your Honor, at this time, the plaintiff calls Mr. Carson Gray to the stand.
Have a seat, sir. Witnesses have been pre-sworn, correct? Thank you.
Yes, Your Honor. May I proceed, Judge?
You may.
Good afternoon. Can you please introduce yourself to the jury?
Yes, my name is Carson Gray.
Can you tell us why you're here today?
I was the victim in a car accident that occurred in September 2017.
Carson, where do you currently live?
I live here in Steels.
How long have you lived here?
I've been here since I guess since 2017, so only 5 years.
Do you recall the date of the crash that we're here about today?
So it was September 4th, 2017.
And where were you living on September 4th, 2017?
I was living here in Steels.
Carson, where do you work currently?
So I currently work at Dr. Dublé here in Stilton.
And where were you working on September 4th, 2017?
I was working there at Dr. Dublé. I've been there since I moved here.
And for those of us who aren't familiar with Dr. Dublé, what is Dr. Dublé?
So, Dr. Dublé's website, you go and put in your symptoms or stuff like that, and he'll give you back a semi-diagnosis, kind of like a WebMD sorts.
Carson, I want to move you to the events of September 4th, 2017. Was there a vehicle involved in the crash that we're here about?
Yeah, so there was the driverless vehicle from Edison crashed in.
Was there any other vehicle involved?
Sure, I mean, there was the motorcycle, my motorcycle that I was sitting on at that time.
Carson, do you remember the events of that day, September 4th, 2017?
Yes, I do.
Can you please tell the jury what you were doing that day?
So generally, I guess it was a pretty normal day. Woke up, went to work like I normally do, got there 8:30 in the morning, worked a full day, left 5:30 in the evening, and was going to meet a friend at around 6.
Who's this friend?
I was going to meet my friend Vince.
What was the plan that you guys had that you just spoke of?
So we were going to meet at Montana Max's. Vince told me something about wanting to sit down and talk, so we were going to meet up there and have a conversation.
So how did you arrive at Montana Max's?
So I left work 5:30. Montana Max's isn't too far away, so I walked. It was a nice enough day. Headed on over.
Who got to Montana Max's first, you or Vince?
So I don't really know or remember who got there first. I remember seeing him pull into the street parking, but I may have been walking up on the sidewalk, or I may have already been seeing him there. So I'm not sure how you characterize that as to who got there first.
Did Vince come on a vehicle?
Yeah, he showed up riding a motorcycle.
So you said your motorcycle. Let's talk briefly about this motorcycle of yours. When did you buy this motorcycle?
I bought him in 2007.
And can you tell the members of the jury where this motorcycle spent the better part of 2017 until this incident, this crash?
Sure. So when I bought the bike, I didn't have my motorcycle license at the time. I couldn't ride it. Vince had his license, so I let Vince hold on to it for a little while.
Carson, did you ride this motorcycle during that year before you got your license?
No, I didn't ride it.
So you said Vince pulls up on your motorcycle. What did he do next?
Well, I mean, he pulled into like the street parking kind of parallel to the curb. And then he got off and jumped on it to sit on the motorcycle for a little while.
Now, Carson, I'm going to sort of try and recreate this using the space in front of the jury. Rather than have you come down and do it, I'm going to just ask you if what I'm pointing out is correct, and you can say if it is or isn't. Okay. So Carson, if this is Montana Max is over here, and this is the curb, what did Vince do? You said he pulled in and parked. Was it like this?
Yeah, he parked right there, parallel to the curb.
What did he do once he was here?
I mean, he put the kickstand down, put it in neutral and got up.
Okay, so I'm gonna pause right there. What is this over here, if anything?
So that would be, I guess, Webster Street. That was the street that we were, Montana Max is on.
And what if anything, excuse me, what if anything is right here in this space? So it'd be in front of where Vince parked. What's over here?
So the library pickup spot is right in front of was kind of right in front of where the motorcycle was parked.
Is the library pickup spot marked in some way?
I mean, it's marked on the ground, and then I'm pretty sure there was a signpost kind of where it was.
When Vince parked his motorcycle, was he in the library spot at all?
No, I mean, I know his front wheel was probably a little bit behind the library pickup spot, but he definitely wasn't in it.
And when you say behind, excuse me, when you say behind for the record, you mean on this side, away from the library spot? The wheel
Yeah,
was on
so
this side.
like, yes.
Okay, thank you, Carson. And so you said Vince hopped off the motorcycle. It was still running. What happened next?
Well, like I said, I've been with my bike. It's been parked at fences, so I haven't really gotten to mess with it or sit on it. So I wanted to sit on it and kind of feel with the engine running underneath me and kind of just sit on it for a minute.
Okay, Carson, would it aid the jury in understanding your testimony if we could somehow get a diagram on the whiteboard?
Sure. I think so.
Your Honor, may I pull the whiteboard
You may.
a little closer?
You may.
And rather than have Mr. Gray stand up and get out, may I have him instruct me on the drawing?
You may.
Thank you, Your Honor.
And Your Honor, may I move just to be able to view?
Yeah, if there's ever anything showing that's being presented to the jury, you don't have to ask for permission, just get up and move to where you can see it.
Thank you, Your Honor.
Your Honor, can you see that okay?
Yes.
So Carson, I'm going to draw 2 lines for Webster Street, okay? And you tell me if this is correct.
Yeah, that looks, no, that's represented on the street. Yeah.
So which side of these lines is Montana Max is on?
On the, I guess, bottom side of it.
I'm going to draw a square and I'm going to put an M in that square. Does that look representative of what you just told me about Montana
Sure.
Max? So Carson, in relation to this, what would this line be right here?
I guess that's the, like outside of the street,
Okay, what do we call that?
I guess the curb.
Okay, and I'm going to draw some dotted lines right here, okay? So in relation to this, where is the motorcycle parked?
Probably down on the, yeah, close to in front of Montana Max's, a little bit further down the street, a little bit further, no, the other way, right there.
Okay, on this side of the line,
Yes,
on the top side. Is that about where the motorcycle is?
yes.
I'm gonna mark that with an X. And so from there, where's this library zone we're talking about?
It'd be pretty much immediately in front of where the motorcycle is.
So can we say right here?
Yes.
Tell me if I've represented that correctly.
Yeah, that looks pretty accurate.
Okay, I'm gonna write library in here. In my very poor handwriting. How does that look, Carson?
That looks how I remember it.
Is this an accurate representation of how the scene looked that day?
Yes.
Your Honor, the plaintiff moves to preserve this demonstrative at this time.
That's fine. You don't need permission to preserve a demonstrative, counsel.
Thank you, Your Honor. So Carson, where are we as far as you've now sat on the motorcycle? What happened next, if anything?
Vince mentioned to me that there's a car coming down, one of those driverless fiber cars. So I was excited to see it. I'd heard about them, but I didn't know that they were operating, so I wanted to turn around and look.
So as you're sitting here, if this is still the curve, where is Vince in your periphery, or where is he?
He's to my right.
So Vince is here
Yeah,
and he says,
there's a library, or one of the driverless cars coming down the road.
so which way do you turn?
I turned over my left shoulder.
Okay. And what did you see, if anything, when you turned over your left shoulder?
I mean, I saw the car that he was mentioning coming down the street.
So going back to this demonstrative, about where would that car be when you saw it?
I mean, it was down the road still, further down. I think it would be probably out there.
Okay, and I'm gonna put an E for Edison / Liber. Does that look about right?
Yeah,
And Carson, just so I can indicate on here, which way are your front tires facing? This way or to the left?
I'm facing towards the library.
Okay, draw a little arrow there. And which way is the front of the car of the driverless vehicle you saw? This
Yeah,
side?
it's facing the same place as motorcycle.
Okay. What, if anything, did you notice at that point?
I mean, just looking over my shoulder, I could see the car was coming down the road. Just seemed like it was coming kind of right at me. And didn't seem to be slowing down at all.
What do you remember next?
Well, at that point, then I remember waking up in the hospital and it's kind of the last thing I remember from that incident.
Carson, just to back up to where you last remembered sitting on a motorcycle, were you aware of your surroundings in general?
Yes, it was.
Did you notice anything besides the driverless car that was coming in your direction?
No, I mean, just the car.
Was there anything between you and the Liber vehicle, the Edison vehicle?
I don't remember it being anything.
So Carson, when you woke up in the hospital, what was that like?
I mean, it's pretty scary. It's confusing, waking up in the hospital room and not really understanding how you got there, so what's really wrong with you at the time, but it's pretty scary.
Was there anybody there waiting for you?
And then besides the doctors and nurses, no.
What's your understanding of your injuries?
I had broken both legs. I had dislocated my sacroiliac joint. And then I had a closed head injury that was just resulted in me losing consciousness.
Carson, I think we heard legs and heads, but you said a sacroiliac joint.
Yes,
Can you just briefly stand up, if it wouldn't hurt you too much, and just show us generally where a sacroiliac joint is, as far as you understand?
sure. So it's your sacroiliac joint's kind of like where your head connects to like your pelvis connects to like your spine. So back in this area.
Carson, how long did you spend in the hospital?
I was there for 2 weeks.
And while you were in the hospital, were you in any pain?
I was in a tremendous amount on the hospital.
You said tremendous pain, but some people are numbers, not words people. If we put that on a scale of 1 to 10, 1 being almost nothing, 10 being the most excruciating pain a human being can imagine, what was your pain level when you first came to?
I mean, I think if I was able to, I'd say higher than that. The purpose of this, yeah.
At the end of the 2 weeks when you were released from the hospital, can you describe in words what your pain was like then?
I mean, I guess the treatment and medicine was helping some, so 9.5, maybe 9.
Carson, what was wrong with you, if anything, functionally, when you were released from the hospital?
Well, I'd broken both legs, so wasn't able to walk, and I had to figure out how to do that again.
How did you leave the hospital? On your feet, on something else?
I mean, I left in a wheelchair, leaving the hospital.
How many months were in the next part of your healing process?
I mean, I guess I had to go physical therapy for 6 or 7 months, so
What was the objective, if any, of your physical therapy?
really just to get me back on my feet and teach me how to walk again.
What was that like learning how to walk again?
It's tough. I mean, it's exhausting. Little movements are hard and just it was really, really difficult.
What was it like for you having to wake up on a day during that time when you were learning how to walk again?
I mean, it was tough. It's tough to try and manage day to day to find a way to get out of bed, find a way to get to the bathroom, to shower. So
What, if any, effect did this have on your sleep?
I mean, it was pain constantly, so it's not easy.
Carson, how often were you going to physical therapy?
So initially, I started off at 4 times a week. Thankfully, I got better and I went to 3 times a week, then 2 times a week.
Do you know if you incurred any medical costs for all this great medical care that you were lucky to receive?
I definitely did.
And are you aware of an amount?
So I know that all my doctor's bills were like $125,000.
Your Honor, at this time, I would like to read a stipulation into the record
You may.
for opposing counsel at stipulation 21, please. And now come the parties, file within stipulations to be used at trial, which shall have the binding effect of being taken as established facts, if so offered. Number 21 says, plaintiff has properly and timely filed medical records and bills showing $125,000 in past medical treatment. The parties have stipulated to this amount in past medical expenses incurred by Carson Day. Carson, does $125,000 cover all of your financial losses from this crash?
No, I don't think $125,000 comes close. Doesn't include my lost wages, doesn't include therapy and medication. Anything that comes close.
So let's talk about your lost wages. Were you receiving a salary at that time?
Oh, as Dr. Bucco was paying.
What was your salary?
So I made $4,000 a month. Well, at that
Did you receive anything like a bonus ever at that job?
time. Yeah, I mean, I received bonuses occasionally.
Were you able to receive a bonus while you were out of work?
I didn't, I was out of work. They weren't paying.
Were you able to get a raise or anything like that while you were out of work?
Yeah.
Did you get any promotions?
No, I didn't.
And you mentioned therapy. Can you tell the jury what your therapy involved?
So I've suffered a lot of panic attacks. So I'm seeing a counselor a lot to kind of help work on those.
Do you know what your costs are from that per month?
Between therapy and the medications for anxiety and depression, pay about $1,000.
Carson, before this crash upended your life, did you have anything physically wrong or any physical infirmities with your body before September 4th, 2017?
No, I didn't have any.
Were you seeing a therapist for counseling or any therapy issues for your panic attacks though?
I was seeing a therapist before.
Did your panic attacks increase or decrease or what after this crash?
It's definitely increased, not more frequent.
Is it possible for you to put a number to that for the jury as far as to the increase in panic attacks?
I would say they doubled, if not more.
Carson, what if any injuries do you struggle with right there as you sit today?
I mean, mostly I'm still just sore, in pain. I've got a limp occasionally, and I don't know what I deal with.
Carson, are you healed from your injuries?
I don't know what you mean by healed. I would say yes and no.
Could you please explain that to the jury?
Well, I guess if you're asking, am I healed to the extent that I don't have broken bones anymore, I don't have a dislocated joint? And sure, but if you're asking, am I the same as I was before? Absolutely not.
Thank you, Carson. Your Honor, may I briefly confirm co-counsel?
Yes.
Your Honor, we passed the witness.
Thank you.
May I proceed, Your Honor?
You may.
Good afternoon, Mr. Gray. Can I ask you a few questions about your injuries?
Absolutely.
I'd like to talk first about the closed head injury you suffered. It is healed now.
That is, yes.
Now, when you were parked, that was in the street, right?
It was along the street, yes.
If we could refer to the demonstrative, so that line right below you, am I correct in understanding that's the curb?
That is the third.
Okay, so it's a mixed moving lane / parking lane, is that how it was?
I think that's probably a good way to describe it, sure.
All right, when you were hit, Mr. Gray, were you wearing a helmet?
I wasn't, but I wasn't riding motorcycles.
Okay, I'd like to ask about your mental injuries, if that's okay? Okay, you had already mentioned you had been seeing a therapist, taking medications before. Now, those medications, Paxil for depression, right?
That's correct.
Okay, Klonopin for anxiety,
Yes,
and Xanax for the panic attacks, right?
yes.
Okay, now the method of taking them, the Klonopin and the Paxil, you take those once a day, every day, right?
Yes, that's how it's prescribed.
Okay, have those doses increased since this crash?
No, they haven't increased.
Okay, the Xanax dose, has that increased since this crash?
I take it more often because I have more panic attacks. That's if that what you're asking.
If that's what's causing you to take it more, I'm just asking for purposes of damages.
Objection, sidebar.
Overruled.
As for the therapy appointments, you see your therapist more often now?
I do see my therapist more often.
Okay. About how many more times per month?
I'd say probably twice as much as I was.
And you stated right now that your mental health, it costs about $1,000 a month, right?
Yes.
Would you be able to quantify out of that how much is directly from this wreck, just changes that have happened since the wreck?
I don't think I could, because I don't know how much I would have healed from the stuff before the wreck.
Okay. I'd like to talk about something a bit nicer, your motorcycle, right?
Yes,
Are you still able to ride it?
I am.
You were here for opening, right?
I was.
You heard opposing counsel talk about it's your one passion and one passion only. Is that a fair characterization?
I'd say I'm pretty passionate about my motorcycle. Yes.
Okay, but you're still getting these panic attacks, right?
I am getting attacks.
And am I reasonable in assuming that these panic attacks are from the wreck?
I think the increase in panic attacks. Yes.
And you were on your bike, your motorcycle when you were hit, right?
Yes.
You ever get these panic attacks while you're on your motorcycle?
They could happen, and I can't remember of a time right now that they did.
But they could happen?
They could.
Okay, and when you have a panic attack, you take your Xanax to help with it, right?
That's true.
Now, as far as the day in question goes, the weather was nice that day, right?
Yeah, it was a nice day.
About 6 p.m., right?
Yes, that's what's on.
It was early September, Labor Day weekend.
Yep.
And so nice and sunny outside, right?
Yes.
And you had that driver's test the very next day.
The motorcycle test. Yes.
Sorry, excuse me. But you're sitting on your motorcycle, right?
That's correct.
You're, I'm guessing, getting in the headspace for the test.
I guess you could say that. I was really just enjoying the bike.
Of course, yeah, it's your bike, right? The engine's rumbling under you, right?
Yes.
And you still maintain that you had no intention of riding that bike,
I did. I just wanted to feel the bike and
and it's not possible at all that you may be misremembering.
I mean, I'm the way I remember it is I was just sitting on the bike.
Of course. Thank you, Mr. Gray. Pass the witness, Your Honor.
Thank you. Anything else, Mr. Krumpholz?
No redirect, Your Honor.
Thank you, sir. You may step down. Yes, ma'am.
Your Honor, the plaintiff calls Mr. Tony Stork to the stand.
Name again, please.
Tony Stork.
Stork, thank you.
May I proceed, Your
You
Honor?
may.
Good afternoon, Mr. Stork. Would you please introduce yourself to the members of the jury?
Hello, my name is Tony Stork.
What are you here to talk to us about today, Mr. Stork?
I'm here to talk about what caused the accident with Carson Gray was in.
And before we get into your opinion on that, I want to give the jury a sense of why you're qualified to give that opinion. What's your background?
I'm an experienced mechanical engineer and I've worked with automated vehicles for most of my life.
What kind of education did you have to get to become an engineer?
I got my bachelor's in mechanical engineering from Carnegie Mellon, and then I got my master's in advanced computer science from Caltech
How long ago did you get that master's degree?
22 years ago.
And did you start working after you got your master's degree?
I did. I was the lead mechanical engineer for a company that designed, implemented, and installed autonomous features in the cars.
Are you still doing that?
No, about 10 years ago, I left that position and I started my own scientific research company.
What does that scientific research company do, Mr. Stork?
We look into the causes of automobile collisions for the federal government, companies, and individuals.
And what kinds of automobiles specifically?
All types, standard cars, automated cars, whatever lies itself.
Now, does your firm do anything else?
Sometimes we're asked to share our findings in trials and courtrooms like this.
And when you're asked to share those findings, have they typically been for the plaintiff side or the defense side?
My company does about even work, but personally, I believe I've testified a little bit more for the plaintiff, but that's just how it worked out.
And for the sake of full transparency with the members of the jury, do you get paid to give your opinion?
Yes, I'm paid to do what I do, to review the materials, and it's also based on my experience and my expertise in the field.
Thank you. Now, before we continue, we've heard you say automated vehicles a couple of times. Could you just take a moment to explain to us what that is?
Sure, basically, it's a car that can do certain things on its own without the human behind the wheel having to do it.
Could you give us an example that we might all be familiar with?
Sure, actually, most cars are equipped with automated features like cruise control, lane detection, sensoring, that sort of thing.
Are there any other examples that you can think of?
Well, more advanced automated vehicles can do most of the driving without human involvement.
So just to clarify, would that mean that the cars could drive without somebody actually behind the wheel?
Well, sometimes there's varying levels of automation, but higher, more advanced automated vehicle is supposed to drive without much human control. And then there are lower levels where those automated features I talked about are still there, but a human should be behind the wheel to take control if something happens.
And the ones that you mentioned that are completely automated, can those operate under all types of road conditions?
They're supposed to, they're marketed to, but that isn't always the case.
And I do want to get to that, but first of all, I want to talk about what your, oh, excuse me, let me go back. These driverless vehicles, before a company puts that type of vehicle out on the road, what's something that they should know?
Well, a company who develops and puts these cars out on the road should ensure that they're as safe to drive as a vehicle with the driver behind it. Be able to detect, lane markings, objects in the road, stuff like that.
All right, and finally, I would like to get to your opinion in this case. What materials did you review in order to form your opinion?
I reviewed the depositions of Mr. Carson Gray, Keaton Sint, and Chad Shanton, and I also reviewed all the exhibits of the joint exhibit list.
And are these the types of materials typically relied upon by experts in your field?
Yes, they are.
And do you hold your opinion with a reasonable degree of professional certainty?
I do.
Go ahead and tell us that, please.
It's my professional opinion that Edison knew or should have known their vehicles had the potential to strike people and hurt people. But they put them on the road anyways, and that's how Carson Gray got hurt.
And could you elaborate on what specifically you feel that these vehicles cannot do?
After reviewing all the materials provided for me, it became concerning with a pattern where the Edison vehicle wasn't able to detect two-wheeled vehicles. And in this instance, Carson Gray was on a motorcycle, a two-wheeled vehicle. To my professional opinion, the Edison driverless car didn't detect Mr. Gray, ran into him.
And I want to walk through how you formed that opinion. Your Honor, may I approach the witness?
You may.
Mr. Stork, I'm handing you what has been pre-marked as Exhibit B. Now, without going into its contents, could you tell me what I've just handed you?
These are a series of emails.
And who are they?
They're between a former Edison engineer, Darren Ryan, and the CEO of Edison, Ethan Sim.
And how are you familiar with these emails?
I've seen them before. They're part of my review.
And are they a true and correct copy of those emails as you viewed them originally?
Yes, it appears to be.
Your Honor, this time I offer Exhibit B into evidence.
Objection, Your Honor.
What's your objection?
These emails are hearsay. And also, if we may approach, they also contain some material that we discussed in MILs.
Discussed in what?
The motion in the May.
Thank you. Okay, this,
Your Honor, would you like for me to respond to hearsay?
we will in
first?
just a second. We're now constructively at the bench. Yes, ma'am. Is this or is this not hearsay?
It is not hearsay, Your Honor. These are statements by a party opponent being Edison Vehicles. These are emails between employees of Edison Vehicle at the time of the incident, operating within the scope of their employment. Darren Ryan is no longer an employee, but at the time of these emails, he was an employee, and of course, Peterson is an employee of the company.
These emails also contain incredibly inflammatory.
Hold on just a second. Let's stick with the hearsay objection. Anything else on your hearsay objection?
Well, Darren Ryan is not a current employee of Edison.
Was he an employee at the time these emails were written?
Yes, Your Honor.
Anything else on that objection?
Not on that objection.
That objection's overruled. Okay, and there's information there that's incredibly prejudicial. Is that what you said?
Yes, Your Honor.
And what is that information?
At the first sentence of that first email, there is some inflammatory language against Edison about, it's talking about taxes. And then also in that first email regarding the motion in limine, it references the Hyperloop situation that we discussed previously.
Okay. Ms. Lawrence?
Yes, Your Honor, with regard to the tax things, as well as this Hyperloop thing, we're happy to constructively redact.
Anything else?
I believe that's.
Okay.
That's
The objection to the first sentence in the April 14, 2017 email is sustained. It should be redacted. And the objection to the last sentence of that email is also sustained and it should be redacted. Otherwise, any other objections to these emails?
Yes, I believe we've also identified a couple other statements in other emails, and those are also inflammatory. They go along the same lines.
You have to be specific, counsel. You got to tell me where they are and what they are.
Yes, Your Honor. In that second email, there's a second reference. I believe it's the last paragraph or last sentence at the bottom, again regarding taxes. That one we would like
That paragraph will be deleted. What else?
and then that would be it, Your Honor.
Okay.
Your Honor, just to clarify, in the first sentence, we would just like to keep the part that says on the first email, Your Honor, but we have a real problem here with the marked ones. Just to clarify that.
Is that not clarified in the remainder of the email?
Yes, Your Honor, that's fine.
Okay, so Exhibit B is admitted, with the exception of those portions that we've already discussed should be redacted.
Yes, Your Honor, and at this time, I'm gonna have my co-counsel publish these to the jury, if that's okay. Publish this exhibit.
We'll do that on the electronics if possible.
Yes, Your Honor, on the elbow, if that's
Thank
okay.
you.
And if you would just put the first email, please. And Mr. Stork, I want to ask you about these emails. Would you please read this email for us?
Yes, this is from Darren Ryan to keep consent. We have a real problem here with the Mark Ones for the second time yesterday. One of the Mark Ones drifted too close to a bicycle that was traveling on the road. I had to take control of the vehicle. This is the second time this happened to me when I was out in the field. I know a couple of other members of the team have mentioned other incidents, but they are too afraid to tell you about it. I've since performed some analytics and I think the LiDAR is having trouble recognizing the bicycles. I think we need to put a halt on the testing so we can figure this out so nobody gets killed.
Thank you, Mr. Storking. Could you, reading this email, could you clarify how this relates to your opinion here today?
Right, this is a employee of Edison, a lead engineer of Edison, essentially pleading to the CEO that there's an issue and it needs to be addressed.
Now, I'd like to go on to the second email, please. I'd like to hear the second email. Now, would you please read this part of the email?
This is from his key consent to Darren Ryan. Darren, have you been drinking again? Because I cannot for the life of me imagine why you are emailing me at 3 in the morning. I looked at the tapes. From what I could tell, the bike swerved at you.
Now, Mr. Stork, you're an engineer, correct?
Yes.
Is it unusual for engineers to work at odd hours?
No, depending on the project, you can work throughout the day.
Thank you. And now the third email, please. And would you please read these for us?
Right, this is from Darren Ryan to key consent. If you looked at the tapes, you know damn well that the bicycle did not swerve at us. This is a problem, and I think we need to shut down the program until we fix it.
Thank you. And now I would just like to go ahead and skip to the email on page 58. And I would like for you to just read that last line for us, please.
I want my objection to the continuation of the project noted.
And just the last email, please.
Noted.
And please send this email.
That was key consent to Darren Ryan.
So reviewing these emails, what is your impression of this?
Multiple times, a lead engineer of Edison tried to warn the CEO that the vehicle was having issues, and from these emails, it appeared that the CEO dismissed these claims.
Thank you. And if my co-counsel would just put that last email on the projector for me, please. Or any of the emails, fine. First email, here we go. Mr. Short, what is the date of this email?
That is April 14th, 2017.
Thank you, Mr. Short. Your Honor, may we constructively approach?
Yes.
At this moment, I would like to get into something that was discussed in MILs. This is the Buffalo Niagara incident that occurred in 2012. I believe this expert has laid the foundation to get into this testimony, as he gave his opinion that he believes that this accident occurred because his vehicles cannot detect lane markings. They cannot detect two-wheel vehicles. Additionally, he has testified that these types of driverless vehicles should be able to operate under all road conditions. And therefore, I do believe it is relevant to today's testimony, and I would like to get into it.
Tell me why you think a vehicle not manufactured by this company should be brought into this case.
Your Honor, this vehicle that I'm about to reference is manufactured by the same company.
Your Honor, this vehicle, it is the same, it is manufactured by the same company. However, it is weather related and therefore has nothing to do with the operating systems. It has.
What is weather related?
The reason why this accident occurred is weather related. It had to do with the ice on the roads, not with the operating system of the vehicle, which is what's in question, whether or not there was a malfunction that caused this collision, whether or not they could recognize the bikes and not whether or not they could operate under icy conditions.
Well, we're up at the bench right now. Normally, I would want to get more information about the prior incident, which I'm constructively not going to do at this time, obviously. Your request is granted, your objection is overruled.
Thank you, Your Honor.
Now, Mr. Stork, at this time, I would like for you to guide me through a timeline of events. And I'm just gonna grab this board real quick, Your Honor. I'll move it a little bit closer so y'all can see. Are you able to see that, Your Honor? All right, Your Honor.
Yes.
Now, Mr. Stork, what I want to do is I want you to guide me through the timeline of events because I want to get a sense of how else you're forming this opinion. You've seen these emails and I want to know what other events have led to your opinion. So I'm just going to go ahead and draw a timeline on the board. Let me adjust it so the jury can see as well. Now, was there a first incident that raised concern about these vehicles for Edison?
Yes, upon reviewing all the information I had available to me, I came across a incident in a simulated test in 2014 where an Edison vehicle actually hit a parked bicycle.
And I'm going to go ahead and write 2014 on the left side of this timeline. Mr. Stork, what is the date of the accident we're here talking about today?
September 4th, 2017.
All right, and when were these first driverless vehicles put in these 3 test cities as livers?
Right, so that partnership and the rollout of that plan occurred in February of 2017.
I'm writing February 17. Now, was there a second incident that caused you concern with these vehicles?
Yes, a month after the initial release of these vehicles in March of 2017 in Buffalo, Niagara, there was one of these driverless vehicles that actually ended up on the sidewalk.
And remind us, what were the date of these emails right here?
That following month, April of 2017.
And at this time, I'll preserve this demonstrative, Your Honor. Now, Mr. Stork, after this 2014 incident that we talked about, did Edison make any changes to their vehicle design?
Not that I'm aware of.
After this March 2017 incident in Buffalo, Niagara, did Edison make any changes to their vehicle design?
Not that I saw.
After these April 17 emails from Darren Ryan, did Edison make any changes to their vehicle design?
No, they did not.
Now, Mr. Stork, we've heard about these events. We've heard how you formed the opinion that Edison knew that these vehicles were having problems. But how do you think that this exact accident occurred, the September 4th, 2017 accident?
Based on these alarming patterns of incidents, it's my professional opinion that this vehicle cannot detect smaller vehicles, particularly two-wheeled vehicles. Carson Gray on September 4th, 2017 was on a motorcycle and he was positioned parked in front of a LIBOR drop-off zone where that vehicle was supposed to go. But it didn't recognize Carson Gray on his bike and hit him from the behind.
Thank you, Mr. Stork. Pass the witness.
Thank you. Ms.
Your Honor,
Nuenke,
may I move to demonstrative?
you may.
Mr. Stork, when you were working at Edsel, you were developing autonomous safety devices.
That's correct.
And one of these was a blind spot monitoring technology.
That's correct.
And one of these was an adaptive cruise control.
Correct.
And you were doing this with the goal of making the road safer.
Yes,
In fact, you wrote an article in 2010,
I did. Yes,
and that was titled, "Can Your Car Drive Better Than You?"
it was.
Autonomous safety devices can help reduce the risk of human error. Is that correct?
I agree with that.
Because autonomous technology isn't subject to the same distractions that human drivers are.
Sure, I'd agree with that.
Autonomous technology can't text and drive, right?
Right, it's not a human.
Right, and autonomous technology can't drink and drive.
Right.
Autonomous technology can't tailgate,
Ideally, it wouldn't.
and autonomous technology can't reach for their phone under the seat if they drop it.
No,
However, these vehicles can still be subject to some of the same conditions that human drivers can be subject to. Do you agree with that?
conditions like,
Conditions like you just discussed, weather.
sure,
They can't defy gravity, right?
no, they cannot.
Nor can they defy the laws of physics, right?
No, they cannot.
And you're an engineer, you're familiar with physics, right?
Yes,
And you know Newton's first law of motion,
sure,
that an object in motion stays in motion unless acted upon by another force, right? Is that right?
yes,
So when you press the brake of your car, it acts upon the car, right?
that's how braking works. Yes,
And that creates friction to bring that car to a stop.
yes,
And physics makes it impossible for this car to stop instantaneously, right?
cars cannot stop instantaneously. Correct.
So even if a car brakes the second that a hazard is detected, it would still take a little bit of time for that car to come to a stop.
Right, it cannot stop on a dime.
And so even level 5 cars, as you discussed, would still be subject to the laws of physics.
Correct.
Informing your opinion on this case, you just spoke about some previous incidents that you reviewed, right?
That's correct.
And one of those incidents involved the allegations by Darren Ryan.
Right, that, yes, email exchange.
And Darren Ryan alleged that in a virtual simulation, a bike was nudged.
I believe that a bike was hit in a 2014 simulation, correct?
And this was never recreated.
Recreated outside the simulation?
In the simulation, this never, to your knowledge, based off the material you reviewed, it never happened again in the simulation.
No, yeah, I'd agree that it didn't happen again.
And it was a one isolated incident that occurred all the way back in 2014.
That's when it did occur, yes.
And during all the years of testing, no bikes were actually ever hit out on the roads, right?
During the testing, I didn't come across that, no.
And in that investigation, there was an investigation conducted, right?
I believe Edison did conduct an investigation.
And they reviewed the tapes.
That's what Keaton said.
And you have no idea when Sent watched that footage, do you?
Excuse me.
You have no idea. Sent said in those emails that he reviewed the footage, right?
That she reviewed the footage, yes.
Yes. And you don't know when exactly she reviewed that footage.
It had to have been sometime between those 3 hours of the reply.
Right. You know that she emailed back in 3 hours.
Yes, that was the time.
You don't know if they had talked in person about this before.
No, all I know is from those emails.
You don't know if it was a day before.
No, all I know is from what I've read in those.
You don't know if it was 4 days before.
No, ma'am.
You don't know if it was a week before.
No, ma'am.
In this investigation that was conducted, they determined that there wasn't any danger, right?
That's what Ms. Sent said in her emails.
And they determined that this bike swerved at Darren Ryan.
That's what Ms. Sent determined, yes.
And Darren Ryan wasn't the only employee that was testing these vehicles, right?
I believe there were many engineers and employees testing these vehicles.
But in your review of all materials for this trial, that was the only complaint that you actually ever saw, right?
Right, in the mentioning of the other team members having similar concerns but not voicing it.
That you never saw any other complaints.
Right, no, that's all I said.
And you are aware that there was an open investigation into Darren Ryan at the time of this complaint.
I am familiar with that.
And this was for creating a hostile work environment.
I believe that was the reason, correct?
And you also talked about another incident. You talked about a Buffalo Niagara incident.
Yes,
And on that day in question, there was a sudden temperature drop, right?
I believe that occurred, yes.
And that resulted on ice in the roads.
The roads did ice.
And there were about 30 to 40 other crashes by human drivers, right?
I believe I reviewed that in Ms. Sin's deposition and that was stated there, yes.
There was an investigation into this incident as well.
Yes, an internal investigation.
And it was determined that it was not Edison's fault.
I believe that's what Edison concluded, yes.
And they concluded that it was due to the ice on the roads.
I believe that's what Edison concluded.
Mr. Stork, you're being paid by the plaintiff, right?
I do get paid to do my job.
You're being paid $650 an hour.
That's correct.
And you're getting an $8,000 bonus for being here to testify today. Isn't that correct?
I also have a flat fee retainer that is $8,000, correct?
And when you form your opinion, you're supposed to consider all relevant info, right?
That's why I reviewed everything that was given to me.
Even if that information, and you would include any relevant information in your report, right?
I would be as thorough as possible.
Even if that information goes against your client, right?
I agree.
And you agree that Carson Gray's behavior is relevant in this case.
I suppose.
But yet, in your report, you never mentioned anything about Carson Gray's behavior, did you?
Right. I had no evidence to go off that his behavior played a factor in this incident or this collision.
But you were aware that this was Carson Gray's motorcycle,
Yes, I'm aware of that.
but that wasn't included in your report.
That he owned the motorcycle? No, I didn't feel like including that.
You were aware that he was sitting on the motorcycle,
Yes, I'm aware of that.
but that wasn't included in your report.
No, it was not.
You were aware that the motorcycle was running,
That the engine was on, correct?
but that wasn't included in your report.
No,
And you were aware that after this incident, that the motorcycle was pointed out into the street,
I did see that that was how it was recreated.
but that wasn't relevant enough to be included in your report.
That the much smaller vehicle moved directions? No.
So that's a no.
No.
The only thing that you stated in your report was that the plaintiff's version of events was reasonable.
Correct.
You pass the witness.
Thank you. Ms. Lawrence, anything else?
Yes, Your Honor. Mr. Stork, why didn't you include Mr. Gray's behavior in your report?
Well, it's my understanding that Mr. Gray was simply sitting on this motorcycle when he was rear-ended by a car. I didn't believe him sitting there doing nothing was relevant to put in there.
Thank you, Mr. Stork. Pass the witness.
Thank you. Anything else?
Nothing further, Your Honor.
Thank you, sir. You may step down. Krumpholz, anything else?
Your Honor, before the plaintiff rests, we'd like to constructively read in all of the stipulations that are contained in this case, Your Honor.
The stipulations are constructively read into the evidence at this time.
Thank you, Judge. At this time, the plaintiff rests.
Okay, let's take a 5-minute break. All right. Everybody have a seat, please. Is the defendant prepared to call its first witness?
We are, Your Honor, but before we do, we ask that the jury be constructively removed from the halftime motion.
The jury is constructively removed. Let me, just as a matter of course, you should do that before we take the 5-minute break.
Oh, of course, Your Honor. Thank you.
Go ahead.
Pursuant to Federal Rule 50, we move for judgment as a matter of law. This is a negligence case, tort negligence. One of those elements is proximate cause. plaintiff's case in chief, they talked a lot about things that have happened years prior. They're trying to make a product liability claim, but that's its own cause of action. This is standard tort negligence. We've yet to see any evidence about the vehicle in question on the day of, how that approximately caused the breach of duty and damages to the plaintiff.
How do you respond to that?
Your Honor, a car maker owes a duty to the public to make safe cars. And so we have shown by testimony that Mr. Gray saw an Edison driverless car, that he was hit by the Edison driverless car. Your Honor, we believe we've met our burden at least enough to send this to the jury, that a reasonable juror could say yes or no at this point, but we have brought forth the elements, Your Honor.
Okay, motion's denied. Call your first witness.
Thank you, Judge. Defense called, Ms. Keaton sent.
You may proceed.
Thank you. Good afternoon, Ms. Sent. Can you introduce yourself to the jury?
I'm Keaton Sent. I'm the CEO and founder of Edison Automobile.
And you said you're the founder. How long has Edison been around?
Nearly 2 decades now.
During those 2 decades, what has Edison been doing?
We have been involved in the automotive industry for the entirety of the time the company's been around. But the autonomous space we just got into in 2010. We were obviously interested in getting into it as soon as we could, and that was the time.
Why autonomous vehicles?
We're concerned about safety on the road. This statement's going to sound obvious, but the leading factor in fatalities on the road is humans. But it's also 2022, and we now have another option. So that statement isn't as obvious as it once was.
What does an autonomous vehicle have that a human-driven vehicle doesn't to make it safe?
So I can kind of compare it to a human. Instead of a driver, you have a computer. Instead of eyes and ears, you have radar, LiDAR, and cameras, which the plaintiff's expert, Mr. Stork, did a really good job of going over. Basically, you have systems that are taking the place of human decisions. They are looking for objects around the vehicle. They are looking for the roadway under the tires, and they are sending those signals to a central computer, which steers and navigates the car.
So you've been in autonomous vehicles for about 10 years, right?
12 exactly, yes.
Excuse me, 12. Okay. Let's walk through the steps of what that looks like. What was your first step into the AV space?
2010, we started video simulations, which again, Mr. Stork did a good job of going through our timeline. We did that for 5 years. So a video game that is meant to recreate real world situations. And that was from 2010 until 2015.
So 2015 rolls around. What's the next step?
We put vehicles on the roadway in 3 different US cities, one of them being Stilton. They weren't driverless yet. We had 2 engineers behind the wheel, and that lasted until March 2017.
What purpose, if any, do these engineers serve?
The engineer behind the wheel was there if he needed to take control of the vehicle. And then the second engineer was a redundancy.
Was this any data point that you kept track of?
Yep, we tracked the vehicle's automation rate, which just means whether the vehicle is completely in control or whether the driver is marked as having taken control of the steering wheel. There's more that goes into that definition, but we're comparing the 2.
You said more that goes into that definition. Could you briefly kind of explain that for all of us?
Yeah, we erred on the conservative side. So if a driver so much as brushes the steering wheel, that counts as taking control of the vehicle. Even with that conservative way of tracking, we reached a very high automation rate, which means the vehicle is in complete control.
You said you reached a very high automation rate. Would you happen to know, do you have a specific number?
Yeah, of course. I'm very proud to say that it was 99.5% for the last 6 months of testing.
Once you were done with this testing phase, what was the next step?
We received full authorization from the federal and state government. I can go into all the effort that took. And that means that our cars were fully autonomous. There were no more engineers behind the wheel.
Okay, Ms. Sen, thank you for that explanation. Prior to the accident involving Mr. Gray, to your knowledge, has an Edison vehicle ever injured a human?
Absolutely not.
To your knowledge, prior to September 4th, 2017, had an Edison vehicle ever been found at fault for any car accident?
Absolutely not.
To your knowledge, between March 2017, when that authorization was granted, and September 4th, 2017, did Edison ever lose any of its authorization to operate?
No.
And to your knowledge, from September 4th, 2017 to now, has Edison ever lost its authorization to operate?
Absolutely not.
Ms. Sen, I'd like to ask you now about a few things that were brought up during plaintiff's case. You were here for all that testimony, right?
I was.
Okay. So you heard about the emails involving Mr. Ryan?
Yes.
I'd like to ask you a few questions about that particularly. Are you familiar with that 2014 simulation that was mentioned?
Yes, and I've had my memory jogged by seeing those emails again.
And I assume, what was your memory recollected by the 2017 incident?
Like everything in this case, things need context. Darren Ryan complained about a video simulation. It is one of millions that were ran during testing. The grains of sand on the beach, that is the number of data points that we were keeping track of. So we took that complaint seriously, investigated it, did not see a concern that should make testing cease, and we continue testing our vehicles.
I know you said you took that concern seriously, but you also said you were here for testimony.
Mhm.
Plaintiffs are saying you only looked at it for 3 hours. How is that possible with what you just told me?
The thought that an engineer would have a serious concern about testing and email me that concern for the first time is ridiculous. Darren Ryan and I had talked in person about this. So when he emailed me and I said I looked at footage, I emailed him back 3 hours later. It didn't take me 3 hours to look at that footage.
I'd like to ask about one more incident that was brought up. Are you familiar with the Buffalo Niagara incident?
Yes,
Did Edison investigate that incident?
yes.
What's your understanding of what happened in Buffalo Niagara?
There was ice on the road and it caused the tire to lose friction with the street, went onto a sidewalk for less than 50 feet, and there was no injuries or damage with the foot.
To your knowledge, were there other vehicles that had crashes on the road that day in Buffalo Niagara?
Yes, I remember during our investigation finding that there were 30 to 40 other vehicles that got into incidents.
And to your knowledge, were any of those other 30 to 40 vehicles autonomous vehicles?
No, only our one vehicle.
The ice on the road that day, am I correct in understanding it was covering the lane lines?
The ice on the road that day was
Yes.
covering all of the road.
Okay, and Mr. Gray, the day of his accident, what was the weather like that day?
I heard it was bright and sunny outside.
One final question, Ms. Sent. Has Edison ever been found to be in violation of any federal or state statute or law?
No.
Thank you. Pass the witness, Your Honor.
Thank you.
Your Honor, may I proceed with cross?
You may.
Judge, with your permission, I'm going to relocate to where the jury's not having to play a tennis match looking between me and the witness, if that's okay.
Where are you relocating to?
May I relocate over here to in front of the bench, Your Honor? On the
For what are you trying to do?
I'm just trying to make it so the jury doesn't have to look between me and the witness.
Why don't you examine the witness from your table?
I'd be happy to, Judge. Good afternoon, Ms. Sent. Ms. Sent, did I understand you to say that your car, instead of eyes and ears, it uses sensors and technology?
Yeah.
And you said, as far as comparing your cars to a human, that your car has a computer for a brain instead of a human being in a human-driven car.
Yes. Okay.
Now, Ms. Sent, I want to take you through something that's going to involve a little bit of math, okay? You're an engineer, aren't you?
I am,
You took some math courses in the course of your engineer training.
yes.
Now, Ms. Sent, would you say that your vehicles during testing went through hundreds of physical simulations, real life, real world simulation events, hundreds for starters?
For starters, do you mean in 2010?
And I'm just talking about altogether. You mentioned thousands and millions of video simulations. I'm asking about real testing scenarios. Would you say they went through hundreds in that 13 months that you guys tested them?
I said millions of data points, but I would agree with you that yes, hundreds during those 13 months.
Thank you, Ms. Sent. Would you say they went through thousands of real world simulation events in that 13 months?
It's possible.
Don't you know?
Do I know the exact number of tests we did off the top of my head? I don't.
Ma'am, would it be fair to say they went through hundreds of thousands of simulation events?
It's possible.
Would you say millions?
I'm testifying about my company on the stand, so I don't know the exact answer. The best I can say is it's possible.
I'll accept a round number from you, ma'am, if you have one for me.
I don't.
So you're real proud of this number, 99.5% automation rate. Right, Ms. Sent?
Extremely
That's a good number, isn't it?
great.
Because when you guys were testing in simulation phase, video game phase, as you say, you had one bicycle get nudged in probably millions of simulations.
That's fair to say.
That's a really low percentage, right?
Yes.
But would it be fair to say that your technology then got worse, not better?
I don't think I'd say that.
Let me see if I can help you understand what I'm saying here. 99.5%, and I hate math just like anybody, but bear with me. Let's say if you guys did 100,000 real world simulation events. I'm bad at math. I assume you're good at math. Can you divide? What is 0.5%? Because that would get us to 100, wouldn't it?
What is 0.5% of what?
What is 0.5% of 100,000?
0.5% of 100,000 would be, I mean, we're talking about less than 10. You want to check that for me?
I would love to have a calculator right now, actually. So 5.5%, 1% of 100,000 would be 1,000. So it's half that, right? Fair?
Can you say that again?
Yeah, so 1% of this big number is 1,000, right?
1% of that?
1% of 100,000 is 1,000.
If you want to give me a calculator, I'll do it for you. Am I on the stand to test my math skills?
Well, ma'am, you're an engineer and you're the head of a company. You have to manage the books too, don't you?
That's an accountant. Do you think an engineer is a pro in division?
Man, this is real simple. 1% of 100,000 is 1,000, right?
If you say so.
I say so, and the math gods say so. So I'm gonna write that number. 1,000 is 1%. So 0.5% is half of that, right?
Can you ask that again?
0.5%. 0.5%. If 1% is 1,000, what's half of that?
500.
Thank you, Ms. Sent. 500. So if we have 100,000 real world simulations, and it's good 99.5% of the time, it's bad 500 out of this many, right?
I don't know how I'm supposed to answer that question. You asked 4.
Ma'am, I just want you to answer as best as you can. If 99.5% automated leaves us 0.5%, well, that's this number right here, isn't it?
If your math is right, I don't have a calculator, like I said.
Thank you. Ms. Sent, you guys put driverless automobiles on the roads of Steelton, right?
Yes,
And as a company that puts automated vehicles on the road, you have responsibilities to the public, right?
we do.
You have a responsibility to put safe cars on the road, right?
Yes, we do.
You have a responsibility to find out if your cars have problems, right?
Yes,
And if you're aware of problems, you have a responsibility to fix those problems, right?
Yes,
And if you find out about a problem, you have a responsibility to take the cars out of the public until you fix the problem, don't you?
no, that's a stretch.
So according to your testimony, it's okay to leave a dangerous car on the road.
That's not what I said.
So then we need to pull it off the road, right?
You're saying a problem. What problem would that be?
Ma'am, I have a great example for you. Does your car hitting bicycles constitute a problem to you?
That would be a problem.
It's a problem for me too, ma'am. So then doesn't your company have a duty to pull a car off the road that's been hitting bicycles?
If we have vehicles that have been hitting bicycles, yeah.
And didn't you have a vehicle hit a bicycle in a simulation in 2014?
A video simulation, you do understand the difference between that and a physical car and a physical bicycle, right?
Well, ma'am, I'm here to find out if you understand the difference. Do you understand the difference?
Might not be great at math, but I understand the difference between that.
Ma'am, I want to show you these emails from Darren Ryan. You recall seeing these emails between you and Mr. Ryan?
I do.
Oh, let's get the redacted version up. It's constructively redacted. Thank you. Ma'am, you know what a Mark 1S is, right? Or Mark 1.
Yes,
That's your prototype car, isn't it?
yes,
And is Darren Ryan an engineer that you hired, your company hired?
yes,
And you guys hire the best engineers, don't you?
I'd like to think so.
And you hire an engineer to do engineer things, right?
To do engineer things like division, yes,
You hire an engineer to diagnose problems.
Yeah.
You hire an engineer to fix problems.
yes,
You hire an engineer to make you aware of problems.
yes,
Ma'am, I'm gonna read this. Tell me if I read it correctly. We have a real problem here with the Mark 1s. Did I read that right?
yes,
Okay. And I'm gonna skip down to right here. I have since performed some analytics, and I think the LiDAR is having trouble recognizing the bicycles. Did I read that right?
yes,
Now, is Darren Ryan some buffoon off the street?
no,
He's an engineer that you hired, right?
yes,
He's your trusted engineer that's telling you he performed analytics, right?
yes.
Well, let's look at your response to this trusted engineer. You said, Darren, have you been drinking again? Because I cannot for the life of me imagine why you are emailing me at 3 a.m. Did I read that right?
Yes.
And then you said, I looked at the tapes. From what I could tell, the bikes were to you. Did I read that right?
Yes,
So you don't address where Darren Ryan says, I performed some analytics on the LiDAR. You didn't check the LiDAR, did you?
yes, I did.
You checked the LiDAR by, what time is this? 6:42 in the morning, ma'am?
I emailed back at 6:42 in the morning. That does not mean that the first time I looked at this was between those hours.
So ma'am, you said you looked at the tapes, right?
Yes,
And this is the first time you're saying under oath that you also looked at the analytics?
this is the first time I've been asked under oath.
Well, ma'am, you gave a deposition in this matter, didn't you?
I did.
And at that deposition, you swore to tell the truth and the whole truth, right?
Yes,
Nothing but the truth, so help you God?
yes,
And did you give that deposition in 2019?
yes, I think so.
So ma'am, I'm gonna ask you once more, have you ever testified that you reviewed LiDAR analytics aside from just looking at the tapes on the record?
You have to remind me what I was asked. I don't know if I was asked that exact question.
Objection, non-responsive.
I don't know how to answer that question.
Ma'am, at your deposition, you were offered the chance to add to your testimony, weren't you?
Yes,
You signed this deposition, didn't you?
yes,
And ma'am, nowhere in this deposition do you say, I also analyzed the LiDAR, do you?
you're not gonna give me that deposition, so I
I'm
can
gonna have to
see?
object to improper impeachment at this point.
Sustained.
Your Honor, I'm still leading up to it, actually.
Okay, then get to it, but that objection is sustained.
Thank you, Your Honor. Ma'am, to your recollection, you don't recall saying anything about LiDAR analytics and reviewing those in your deposition, do you?
I honestly do not recall that deposition off the top of my head. You can hand it to me. I'd love to read it and see.
Objection, there's no question posed to the witness.
Let's ask your next question, counsel.
Your Honor. I can confer with co-counsel briefly, Your Honor.
You may.
Thank you. Ma'am, you testified before Congress regarding your cars, right?
Yes,
And isn't it true that you told Congress your cars are flawless?
that sounds familiar. Yes.
So you think your cars are perfect,
No,
just flawless?
flawless is what I said there. If that's what you're looking at. Again, I'm having a hard time remembering something off the top of my head.
Ma'am, do flawless cars run over people?
No,
Do flawless cars hit parked objects?
no,
Just your cars, huh?
I want to say that.
That's the witness.
Thank you.
Free for your rest, Your
You
Honor.
may proceed.
In this sense, back to Darren Ryan's allegations, at any time, are you aware of any other engineer bringing to your attention issues similar to those being discussed by Mr. Ryan?
No,
And actually, I think that'll be all, Your Honor.
Thank you.
That's the witness.
Your Honor, based on that, I would like to ask a few more additional questions.
You may.
Ms. Sin, counsel just asked you if you were aware of any other engineers who made you aware of problems. You remember answering that question under oath?
yes,
And wasn't your answer that no, they had not?
yes,
Ma'am, I'm going to read for you right here, and I want you to tell me if this is correct or not, if I've read this correctly. I know a couple of other members of the team have mentioned other incidents, but they are too afraid to tell you about it. Did I read that right?
yes.
So in fact, you did have noticed that there were other problems, didn't you?
She asked me if other engineers told me. This is the same Ryan that emailed before that we were talking about. Mr. Darren Ryan, right?
No further questions, Your Honor.
Thank you. Anything else?
No, may this witness be excused?
You, this witness may step down.
I apologize, Your Honor, for getting down early.
Yes, ma'am.
The defense calls our next witness, Nat Romanoff.
Let's see, sir.
Do I have any proceed?
You may.
Oh, Mr. Romanoff, can you go ahead and introduce yourself to the jury?
Hello, my name is Nat Romanoff, and I'm a professionally licensed engineer.
And Mr. Romanoff, can you tell me a little bit about your education history?
Yes, so in 1995, I received my undergraduate degree from MIT in computer engineering and electrical engineering. I furthered my studies there at MIT with a computer engineering master's, and then I got my PhD in electrical engineering, graduating in 1999.
And can you tell us why you're here today?
I'm here because I reviewed all the materials in this case, and I've been asked to provide an opinion.
And for the sake of transparency, are you being compensated for your time?
Yes,
And how much are you being compensated?
I'm being paid $650 an hour.
And you mentioned your education history. After you graduated, what did you do for work?
So I worked for 2 years as a professor at MIT. I taught courses in computational design for automotive industrial equipment.
And after those 2 years, what did you do next?
So then I went on and taught at Steelton University.
And how long were you there?
I was there for about 7 years.
And what were you teaching there?
I was teaching again automotive industrial design equipment.
And what did you do after that?
So then I went on to my current role at RCC.
What is RCC?
RCC is a multifaceted engineering consulting firm, and we review and analyze root causes of an automated machine failure.
And what is your position at RCC?
I'm the CEO and lead engineer.
Based off of your extensive education and work history, have you been able to come to a conclusion in this case?
I have.
And what did you rely on when you were forming that conclusion?
So I relied on the 3 depositions in this case and all the exhibits in the joint exhibits.
And are those materials that are used by others in your field?
Yes,
And do you hold that opinion out to a reasonable degree of professional certainty?
I do.
Okay, we're not gonna talk about that opinion quite yet. We'll go ahead and we'll talk about Edison's design process. Are you familiar with their design process?
I am. They have a 6-step design process that they use in designing and developing their automated.
Do you believe that it would aid the jury's understanding of your testimony today if you were able to use a demonstrative while you testified about this design process?
I do.
Your Honor, permission for Mr. Romanoff to come down for the privilege of the demonstrative.
He may.
Thank you, Your Honor. Mr. Romanoff, can you tell me why this design process is important?
Well, it's important because it's industry standard, quite frankly, to make sure that the products we're designing as an industry are safe.
And you mentioned there were 6 steps. What is step number 1 of this process?
So step 1 is you have to define the problem.
And step number 2?
Step 2 is you perform background research into the problem.
And step number 3?
Step 3 is you brainstorm and basically analyze solutions.
Step 4?
Step 4 is you prototype and input or design a solution.
Step 5?
Test that solution.
And finally, step 6?
Step 6 is you communicate those results to the industry and any regulatory authorities.
Mr. Romanoff, do you believe that Edison complied with every one of these steps in their introduction of autonomous vehicles into the market?
Yes, I know they did.
And can you tell me how they complied with step number 1?
So first they define the problem, and the problem plaguing our roads most today is distracted driving from human elements. And that was their problem that they sought to solve.
And how did they comply with step number 2?
So they perform background research into the problem, again, determining what humans are doing to be distracted. And then they perform background research into some of the highest, most advanced technology available.
And step number 3, brainstorm. How did they comply with that?
So they brainstormed a solution, looking at all that high advanced sensors like LiDAR, radar, cameras, things like that. And they brainstormed what they could do with those sensors.
And step number 4, solution.
So this is when they built their prototype using those high technology sensors, LiDAR, radar, and they came up with their autonomous vehicle.
And step number 5, testing.
So this, I think, is probably the most important step to talk about. And Edison complied with this by starting in 2010 with a detailed simulation program that went on for 5 years. And then they coupled that with real world testing for another 13 months with 2 engineers behind the wheel as a redundancy to the system. And yeah, so that was their testing phase.
And step 6, how did they comply with this step?
So communicate the solutions to the regulatory authorities. They received approval to go driverless, completely driverless on the roads. And they did that, and they informed the industry of their solution.
And do you think that Edison should have done anything differently in following this process?
No, they complied with the process.
Thank you. We'll go ahead and we're zoom in a little bit to the day in question.
Sure.
So in your review of the material, can you go ahead and set the scene for us? Where did this accident occur?
Sure. As we heard from Mr. Gray earlier today. This is on Webster Street.
And what was the road like?
Oh, so this is a 2-lane road, just your standard 2-lane road with some businesses and parking spaces.
Can you tell me about those businesses?
Yes, so one in particular was Mad Max, which you heard Mr. Gray discuss.
And parking on the street, what did that look like?
So it's just street parking on the sidewalk here. And then there was a designated, so this is just a curve. And then there's a designated library pickup zone right here.
Thank you. As for the vehicles on the road that day, where was the library? And which direction was it coming from?
So the library was driving down the road in this direction.
And can you go ahead and label that library for me?
Yes, I'm gonna write ED.
And Mr. Carson Gray, where was his motorcycle?
So his motorcycle was parked parallel right here.
And you heard today that that vehicle or that motorcycle was found pointed out into the street after this collision. Can you go ahead and reflect that on the diagram?
Yes, so after reviewing all the information, the final resting place of the motorcycle was right there.
And what was the library doing at the time?
So before this occurred, the library is continuously moving down the road. And it knows that it's about to pull in this library zone, so it's using its LiDAR and radar to read all of the surroundings as it approaches.
And what were the collision points on these vehicles after the crash?
So for the library, it was the front right of the car.
And for the motorcycle?
For the motorcycle, it was the back left panel.
And based off of everything that you've heard today and everything that you reviewed in preparation for this trial, what is your opinion about what happened here?
So my opinion is the Edison vehicle was going down the road. It was using its LiDAR system and radar and functioning properly. When all of a sudden, Carson Gray pulled directly in front of the Edison vehicle and it had no time to stop, causing this collision.
Thank you. Go ahead, return to the witness stand. And Your Honor, we'll be preserving both of these demonstratives, the first as defense demonstrative 1 and the second as defense demonstrative 2.
Okay.
Mr. Romanov, you were in the room today and you heard about a couple of incidents that occurred, right?
Yes.
And what were those incidents?
The one was the 2014 simulation, the Buffalo Niagara incident, and also the one raised by Darren.
Let's talk about the Buffalo Niagara incident first. What is your opinion on what happened with the Buffalo Niagara incident?
The car slipped on ice.
And as for the Darren Ryan incident, what is your opinion on that?
Those complaints aren't credible. It's from an unreliable source who is already under an HR investigation at the time of the complaints.
And you were also in the room today when the plaintiff's expert, Tony Stork, took the stand. Do you have an opinion on his testimony?
Yes.
And what is that opinion?
It was remarkably one-sided. When I heard Mr. Stork say that the Edison vehicles can't detect bicycles and motorcycles despite 12 years of testing and 5 years of field application now, and one accident, despite the thousands or millions of bikes and motorcycles that these cars must have encountered during that time. So to say that it can't pick up any was just kind of remarkable to hear.
Like you just said, you heard him say that it can't detect any bikes or motorcycles. Does that have any effect on your opinion?
It didn't change my opinion at all.
Your Honor, we pass the witness.
Thank you. Ms. Lawrence?
Your Honor, would it be all right with you if I stood just from right here, or would you prefer
No,
this?
that's fine.
Mr. Romanov,
Dr.
Dr. Romanov, excuse me. I'd like to start by asking you about this exhibit right here. Now, you're an engineer. I'm sure you're familiar with physics, right?
Generally, yes,
And I'm correct that you're not an accident reconstructionist?
correct.
Okay, and do I have it right that the point of impact for the Edison vehicle was the front right of the vehicle?
Yes,
And do I have it right that the point of impact for Carson Gray was the bottom left of the vehicle?
yes, the like left fender.
And we can see here that Carson Gray's vehicle has ended up kind of slanted, as we can see here. Now, you'd agree with me that the Edison vehicles, that's a car, right?
Yes,
And can we agree that cars probably weigh about 2 tons?
argument's sake,
I'm sorry?
I would say it's probably like 3,000 pounds, but
Okay.
yeah, sure, 2 tons.
Sure, I'll agree with you. Let's say a car weighs 3,000 pounds. Can we agree that a motorcycle maybe weighs 500 pounds?
I'll go with you. I honestly do not know the weight of a motorcycle.
Can we agree with each other that a motorcycle weighs less than a car?
Yes,
Okay, and so would you agree that it is feasible that a motorcycle could be sitting where Carson Gray was stationed, could get hit by a heavy vehicle like Edison vehicle and end up in that second position?
no,
You wouldn't agree with that?
no,
You wouldn't agree that a 3,000-pound vehicle can hit a significantly smaller vehicle and cause it to end up in that position?
not with the impact points on those cars.
All right. And you've been an engineer for about 20+ years now. Do I have that right?
Yes, ma'am.
In automated vehicles.
Yes,
Now, would you agree with me that engineers have a social responsibility
yeah, sure.
to make their products safe,
Yeah, generally speaking, engineers, I mean, yes,
like a lot of professions, right?
Yeah.
And they have a social responsibility to ensure that the technology they develop doesn't harm anyone.
yes,
Now, even if it takes a little bit longer to develop the product,
of course,
and even if it takes a little bit longer to test the product.
yes.
Now, I want to have my co-counsel put those emails back up, and I know it feels like we beat this to death, but don't worry, I'm not going to ask you to read them or anything like that. I want to ask you to go with me on a hypothetical. Do you think you could do that?
Sure,
Now, let's say we're not talking about Edison vehicles, we're not talking about Darren Ryan. Let's say the CEO of a firm that produces driverless cars received an email like this from one of its engineers. All right, are you with me?
Sure.
Would a responsible company look into this issue?
yes,
Would a responsible company take its vehicles off the road until it can look into this issue?
No.
You don't agree?
No.
A responsible company would keep vehicles on the road that was having problems, according to one of their own engineers.
well, obviously, looking at one email, it's impossible to provide the proper context to this. But this says it drifted too close. I mean, we need to understand what his definition of too close is. Did it go within a feet? Did it go within half a foot? To pull an entire testing division for one email, that's a bit rash. I would never expect a company to receive one email and act that fast to pull an entire product line off the market.
It would cost too much money, right?
I just think it would be, quite frankly, insane.
Insane.
Yeah,
Would it be fair to say it would be inefficient?
inefficient.
Would you agree? Is it your opinion that it'd be inefficient to take all of these vehicles off the road just because of one incident?
Yeah, it would be outside the bounds of the engineering process.
All right, well, I want to talk about the engineering process. Are you of the opinion that Edison has completed this 6-step engineering process?
Yes, that's my opinion.
So once a product's developed, that's it? Let me rephrase my question. Once that 6 process is complete, the product is safe.
Yes.
And regardless of any issues that might potentially come up, it doesn't matter, right?
Well, that's not exactly how the process works. Generally speaking, you say an issue comes up, that would be you back to the define the problem step.
Gotcha. Okay, so we would actually start over the 6-step process.
If there was an issue, yes.
All right. And so did Edison follow that 6-step process when this problem was brought to his attention?
Yes, it did.
Really?
Yes.
They tested the product again?
Well, if you go back to the process, I can
Sure,
kind
Your
of
Honor,
show.
may I actually?
Yes, but let him finish his answer before you interrupt him.
Oh, sorry, I just want to see what we're talking about here.
Sorry. Yes, so basically this email is step one to find the problem. Darren Ryan is defining a problem. Step two is research. Keaton says he looked into the problem and reviewed the tapes and determined there was no problem. So therefore you go back to step one and wait for further issues.
Gotcha. So there would be no further testing involved with that. Do I have that correct?
No, because they performed the background research and they determined there wasn't an actual problem.
I see. So this 6-step process is kind of, you can jump all over.
Well, if there's no problem, there's no reason to test the solution.
Okay, but you would agree with me that just because a company has completed the 6-step process, that's not the end of the road, right?
Until there's a new problem, it kind of is.
I see. No further questions, Your Honor. Pass the witness.
Thank you. Anything further, Ms. Nuenke?
No need to redirect, Your Honor.
Thank you. You can step down, sir. Yes, ma'am.
At this time, Your Honor, there were no other in-person witnesses for defense to call, but just for my own memory and for the record, may we all assume that Chad Shanton's deposition has been read in constructively?
Who's Chad Shanton?
We spoke about him during pre-trial. He's the witness that's been stipulated to that he has an authentic deposition certified. Both parties are okay with it being read in. He's unavailable and it's been stipulated to. that he's
Okay.
unavailable.
His testimony has been read into the record constructively.
Thank you, Your Honor. At this time, the defense rests.
Any rebuttal from the plaintiff?
Your Honor, at this time, we have no rebuttal, but we would like to make a motion.
Okay, go ahead.
Your Honor, in regards to defendant's affirmative defenses, and I'll point out a page, it's on page 9 and 10 of the problem stack, Your Honor. We would like to move for a judgment as a matter of law on defendant's affirmative defenses. Number 3, number 4. Number 3 and number 4, Your Honor.
Go ahead.
Well, first on number 3, Judge, as far as a superseding or intervening act, the jury instructions in this case can be changed by local rule. There is nothing in the jury instructions regarding a superseding or intervening act, so the jury won't even be instructed on it, Your
Is
Honor.
it your argument here that there's no evidence of any superseding or intervening acts
Judge, I would also
in
make
this,
that,
in this record?
sorry for interrupting you. Your Honor, I would also make that argument.
Ms. Mahoney?
I respond to that argument by saying that we have laid the proper foundation to at least take the question to the jury as to whether the plaintiff's own actions in the original charge constitute that.
But that's not number 3.
Oh, excuse me.
Number 3 is whether or not
I see
claims
that.
for
I do
cause
see
or
that.
contributed by superseding or intervening acts of other entities.
I apologize.
Do you
I
have
missed
any
that
ev-
last part.
Is there any evidence of any other person or entities or circumstances that contributed to this event?
To that end, we will not be making that affirmative defense.
Thank
We
you.
have
The
no-
motion is granted on number 3. What else?
Thank you, Your Honor. I want to correct myself. I meant 2, 3, and 4, but if I may address 4 quickly. 4, Your Honor's failure to adhere to Stilton's traffic laws. We haven't heard evidence that somebody who wasn't going to operate a motorcycle broke the law by not having a helmet and not having a license since he wasn't driving. And there's been insufficient evidence to support the jury even having that affirmative defense in front of them, Your Honor.
Ms. Mahoney?
We also will not be making that affirmative defense.
Okay, the motion for directed verdict on that issue is granted. What else?
Finally, Your Honor, on plaintiff's own negligence, we feel that the defense has failed to establish enough evidence for this affirmative defense for the jury to be able to make, and we are outside the jury's presence, I'm assuming, this whole time, making these motions.
We are.
Thank you, Judge.
You wouldn't
Thank you.
rather make this motion in front of the jury?
Your Honor, I have no intention of making this motion in front of the jury,
Very
but
well.
thank you, Judge. Your Honor, the defense has not established sufficient evidence to show that the plaintiff was in fact negligent. There's nothing for the jury to consider once they come back.
What about Dr. Romanoff's testimony that the plaintiff drove the motorcycle onto the road and that's his opinion about how this incident occurred?
Your Honor, I appreciate that from Dr. Romanoff, but Dr. Romanoff's opinion is based on a police report of some alleged origin and in this case. And so I don't even feel that that's sufficient to sustain it, Your Honor.
Ms. Mahoney?
In response to the Romanov contention, I would respond that plaintiff's own expert also relied on this police report and forming their own opinions. In fact, both experts did, and there was no issue then. Counsel had the opportunity to voir dire the witness if he really had an issue with what our expert was going to opine about.
Motion for directed verdict on the plaintiff's negligence is denied. Anything else?
Nothing further from the plaintiff.
Okay. Are we ready to go into closing arguments?
And our further proceed, we have one matter that we need to bring up. Plaintiff has 6 minutes remaining.
Thank you. How about the defendant?
Defendant has like 37 minutes remaining. I'm hoping the defense does not have 37 minutes to close. However, with the court's indulgence, in order to allow plaintiffs to fully close, would there be going to be an extension of a reasonable amount of time?
Do you speak on behalf of the plaintiffs as
No,
the
Your
timekeeper?
Honor, I request only for purposes of, for educational purposes, that the plaintiff, my suggestion, Your Honor, you sure court, Judge Schaffer.
Thank you. I'm glad you appreciate that, Ms. Weems.
The question, what I propose is that we ask the plaintiff counsel how much they intend to use for their closing, limited only to that amount of time.
Let the court put it this way. If the court were so inclined to add additional time to the plaintiff's clock to close, how much time would the plaintiff be requesting, Ms. Lawrence?
Your Honor, because we are arguing damages in this case, I could get it done in 15 minutes.
The court will allow for the additional time for the plaintiff to close on the issue of damages and any other issue necessary. Ms. Mahoney,
I was going to offer my own time, Your Honor, but.
you are going to
Seems like
offer
we're
the
cut out.
plaintiff some of your time?
Yes. that
Well,
is
that's
correct.
very generous of you and the type of consideration that at least this court greatly appreciates. But there's no need for you to do that. You have 37 minutes available. The court does, however, wish and hope that you don't intend to use the full 37 minutes to close in this instance.
Not at all.
Thank you very much. Okay, Ms. Lawrence, I got it here. I'm in control here. Ms. Lawrence, you prepared to give your closing argument at this time?
If I could have just 5 minutes to gather my thoughts, I would appreciate it.
You have exactly 5 minutes to gather your thoughts. It is
Yes,
now
sir.
5:02. I will be back here at 5:07.
That's fine.
Okay, everybody have a seat, please. Okay, are parties prepared to give their closing arguments at this time?
And Your Honor,
Okay,
I'd like to reserve 2 of my 15 minutes for rebuttal. Please.
you may. Did you let the timekeeper, our uber efficient timekeeper, know about the reservation of 2 minutes?
How many, two?
2.
How would you like 113?
You can do like a 1 minute. Yeah.
I'm just gonna verbally tell you you have 1 minute remaining. I'm gonna tell you when you hit 13 and then talking and you can hear about time. Okay, when we go.
You may proceed.
Thank you, Your Honor.
You may proceed.
Ladies and gentlemen of the jury, this is a case about a tech company that put driverless vehicles on the road, became aware of numerous incidents of those vehicles malfunctioning, and continued to keep those vehicles on the road. And Carson Gray paid the price. Carson Gray got up here and he told you his story. He told you about how he's been riding motorcycles since he was a kid, how he's always loved motorcycles, and how he was excited about the motorcycle that he had bought in 2017. You heard that he got a little ahead of himself and he bought the bike before he had a license. So he had a friend, Vince, keep it for him. And on the day of the accident, Mr. Gray was on his way to meet up with Vince at a restaurant. And Vince was going to bring his bicycle so that he could sit on it and just enjoy that bicycle before he was able to get on the roads. So he shows up at the restaurant, sits on the bicycle, and he turns it into him. closes his eyes, feels the rumble of the engine, and he imagines himself out on the roads when he finally gets his license. Just a moment later, he turns his shoulder and he sees an Edison Liber vehicle barreling down the road. A 3,000-pound vehicle barreling towards him. The next thing he knows, he wakes up in the hospital. Now, I want to get back to Carson Gray's story in a minute, but first I want to remind you of what you learned from our expert, Mr. Tony Stork. He came up here and he told you about his 20+ years in the automated vehicle industry. And he gave you his opinion on how this accident happened. And he told us that he reviewed the materials and he came to the conclusion that Edison had been warned time and time again that something was wrong with their vehicles. And with Mr. Stork's help, I created this timeline for you. 2014, these vehicles are having issues in their simulation stage. Now, I understand that a simulation is not real life. I understand that these vehicles were on the road, but this is the testing phase that their experts spent so long talking about. This is the time for Edison to see the issues with its vehicle and change the software, change the design. Edison didn't do that. Now, February 2017, these vehicles are approved to get on the road, to be put in these 3 test cities and operate as lighters. And just 1 month after they're put on those roads, one of the vehicles in Buffalo, Niagara, ends up on the sidewalk. These flawless vehicles that can operate under any condition end up on the sidewalk. April 2017, Darren Ryan, an engineer on the Edison project, emails Keaton Sin, the CEO and lead engineer of this company, and tells him, hey, something's wrong with these vehicles. One of them hit a bike the other day. We need to get these off the road and figure out what's going on. The vehicle has hit a 2-wheel vehicle, a bicycle, just like it did on September 4th, 2017, and just like it did in simulation in 2014. But Edison's not concerned about that. Keaton got on the stand up here, all smug, unconcerned that its vehicles had numerous issues, and in 2017 hit my client, resulting in significant injuries. She's not concerned. The technology's flawless, the vehicle's flawless. It's absolutely flawless, even though it can operate apparently with a little bit of rain. And apparently it's no big deal, that one isolated incident in a simulation. Oh, well, it's still flawless. All right. And then their expert got up here, Dr. Romanoff, and they constructed this police report, which we haven't heard from this police officer who was there. We have no idea what time he got there, how long ago after the accident it was. We have no idea if these vehicles were moved. We have no idea of anything. And he's basing his opinion that the only way that that vehicle, that bicycle, could have ended up where it was on the road was if it moved. Despite the fact that this 3,000-pound Edison vehicle was barreling down the road and smacked into this motorcycle that Carson Gray was on, he said there's no way it could have ended up in that position. Now, ask yourself, does that make sense? It makes even less sense than the fact that a company like Edison would see all these incidents and not do anything about it, not take their vehicles off the road, not conduct more testing, not go through that 6-step process again that Dr. Romanoff was telling us about. And you heard Dr. Romanoff say that engineers have a social responsibility to make their products safe, to develop technology that doesn't hurt people. Now, I want to go back to Carson Gray's story, because you're not just here today to find Edison liable. You're also here to compensate Mr. Carson Gray for his injuries. The court has instructed you to award reasonable damages based on how much Mr. Gray has suffered in the past and how much he's going to suffer in the future. And so my co-counsel, Jeff Krumpholz, is going to put the first question that you're going to have when you go back into that jury room. And this is going to ask you, did the negligence, if any, of those named below proximately cause the occurrence in question? Now, We ask that you write yes next to Edison Automobile Company and no under Carson Gray. And let me explain what they mean by this. What they mean is, did the carelessness, but more likely than not, did the carelessness of either of these parties cause this accident to happen? And therefore, that is why I would like you to write yes next to Edison and no next to Carson Gray. And because you've answered this way for question 1, we can go ahead and skip question 2. So we'll go right on to question 3. Now, question 3 is going to ask you to award an amount for each of these sections for how much Mr. Gray has suffered. Now, the first one's real straightforward. He testified that his medical expenses in the past were $125,000. So that's what we're going to ask you about. Question 2, future medical expenses that he will incur in the future. Now, you heard about his therapy. You heard about the medications he continues to take as a result of this accident. And you also heard about his physical injuries. 2 broken legs, a broken joint, a dislocated joint in the lower back, a closed head injury. Ladies and gentlemen, these are no bumps and scratches. And he may be able to walk now, sort of, but these are long-lasting injuries that are only going to get worse as he ages. Mr. Gray is 34 right now. All right, he's still pretty young. These types of injuries, they don't go away, and they're not going to get any better as his body ages. So for that, I ask that you award him $1 million. Physical pain and suffering in the past. That's all the stuff you heard about how he had to go to physical therapy for 6 months just to learn how to walk again. He spent 2 weeks in the hospital. His entire life was disrupted by this. You heard him tell you he couldn't sleep the same. He couldn't just go about his daily life the same way. He had to live with that chronic pain, with the fact that he didn't know if he's going to be able to walk right again. And for that, I ask that you award him $3 million. Next is physical pain and suffering that he'll sustain in the future. Now, same thing. He's not walking the same way he was before. He's got a limp. He had a closed head injury. Lord knows what the long-time effects of that are going to be. For that one, I ask that you award him $2 million. Mental anguish in the past. You heard him talk about his mental health struggles. And yes, he did have some mental health struggles before this accident, as he admitted. But he told you that they were significantly exacerbated by this accident. How he has frequent panic attacks. How he's constantly having to go to therapy. For that, I ask that you award him $1 million. Mental anguish in the future. Mr. Gray continues to go to therapy. He'll probably seek therapy for the rest of his life. For the rest of his life, he's going to have to suffer with these injuries, with the trauma of getting hit by a 3,000-pound vehicle barreling towards him as he's sitting there on his motorcycle. And for that, I ask that you award him $1 million. Physical impairment sustained in the past. Now, this refers to the broken legs he suffered, the fact that he had to walk with a limp, the fact that he couldn't shower on his own, couldn't, hang out with friends the same way he did before. For that, I ask that you award him $1 million. Physical impairment in the future. He's still impaired to this day. Still walks funny. And as he gets older, those issues are only going to get worse. Dislocated lower back joint, broken legs, a closed head injury. These are not things that just go away. And they certainly don't get better as your body ages. So for that, I ask for $1 million. Disfigurement sustained in the past. That would refer to that limp he was suffering, the way that looked, having to walk with that limp, having to walk with a broken leg. That disfigurement is something that he suffered with. And for that, I'm asking for $1 million. Disfigurement in the future. Again, ladies and gentlemen, he's still suffering with this limp. He's still suffering with these scars, these injuries that he sustained because of Edison vehicles. And for that, I ask for $1 million. Now, lost wages incurred in the past. This refers to the work he had to miss. Now, he told you he missed 6 months of work, and he gets paid $4,000 a week. And on top of that $24,000 he lost any opportunity for a raise, for a promotion, for a bonus. So I asked that you bump that up to $100,000. And folks, that brings us to 12,225,000. Now, we're not here today to say that automated vehicles are bad, that all of them should be off the road. In fact, our own expert worked in the field for 20 years. He's a fan of these vehicles. But you also heard him tell you that these companies have a responsibility to make sure the technology works, to make sure that these vehicles are not going to hurt somebody. And Edison didn't do that. Edison didn't take their vehicles off the road. And Carson Gray suffered because of it. And therefore, I ask that you find Edison vehicles liable for Carson Gray's injuries. Thank you.
Thank you. You may proceed, Mr. Honey.
May it please the court. Thank you, Your Honor. Ladies and gentlemen of the jury, when there's two competing explanations, the simplest explanation is often the correct one. Those are the very first words out of my co-counsel Hayleigh Nuenke's mouth at the beginning of this trial. I think you'll see, based on the amount of demonstratives as related to evidence and testimony from today, that it really is a battle of two stories, two explanations, if you will. There's two potentialities as to what happened here that faces you jurors. There's the first potentiality, which is somehow a vehicle that has had no credible allegations in it. Allegations, sure, but no credible allegations of its inability to detect motorcycles in particular, suddenly had a fantastical malfunction. 3 different systems. You heard from the experts, camera, radar, that particular LiDAR, the light detecting radar system, all failing at once. That it was never anything that came to Edison's attention, or if they did, they covered it up. But then the federal government, NTSB never had an issue. National Highway Traffic Safety Administration, which is the regulatory agency that licenses it, never had an issue. So you have that potentiality where this is apparently some grand cover up and something that really there's not a lot of evidence to suggest would go wrong, suddenly did. Or you have the other explanation, which is that Mr. Gray did something that happens to, honestly, all of us from time to time. You get caught up in the moment. This is a man who, as plaintiff's counsel said in his opening, had a passion for one thing and one thing only, his motorcycle. I can get that. I know I have a passion for things. Sure, we all have a passion for things. Sure, we all do, right? But sometimes you get caught up in it. Sometimes, like when you're parked in the street, it's a very sunny day, you're taking your driver's test the very next day. You're sitting on your motorcycle, the engine is rumbling beneath you. You think, I'm gonna take this thing out for a spin, even just a bit. What's more likely? Now, before I get into the substance of what was discussed in today's trial, I'd like to remind you of the rules that were read to you for deliberation by the judge prior to our closing arguments and direct you to one sentence. If you only remember one rule, although you should remember all of them, if you only remember one, remember this one. Do not let bias, prejudice, or sympathy play any part in your decision or in your evaluation of the evidence submitted or testimony heard in this case. Look, Mr. Gray, we are genuinely sorry for his injuries. We did not cause them, but we acknowledge that this man has suffered. And he's a likable guy. Honestly, he's a likable guy who made a very innocent mistake, something we all do. He just happened to be in a very wrong place at a very wrong time. Now you look at Edison. A lot of what the plaintiff's case in chief had to talk about related particularly to the CEO, Ms. Keaton-Sent. Now, y'all saw Ms. Sent on the stand. She is headstrong in support of her company and in their ideal relating to automated vehicles. And you also heard exactly why she's so headstrong about it. And that's because she wants to make the roads a safer place. Yes, she may come off as harsh sometimes, but that's because she's defending her vehicles that she's put a decade plus of her life into. All of the engineers in her company have put a decade plus of her life into. Ask yourself, if Ms. Gray is so headstrong because of this obsession with trying to make the road safer. She even told you the leading cause of crashes is human error. Why then would she leave her vehicles out on the road if she thought that these vehicles weren't as or more safe than people? Plaintiff's counsel asked the same thing. That's the duty of care that Edison has been asked to meet today. That duty of ordinary care. And the way plaintiff's counsel said it, we're perfectly happy to agree with it. The ordinary care is that if we know there's a problem with these vehicles, or if Edison knew or should have known that the vehicles weren't as safe as those driven by humans, those vehicles should have been off the road, and them being on the road was the negligence in and of itself. Let's talk about human-driven vehicles, right? We all have cars, I'm guessing, all have driver's licenses, especially where we live. This is a car-driven society. But I'm sure we all know that car crashes, unfortunately, they happen very frequently. Now, Edison has had a single crash involving an injury to an individual in 12 years, 7 of those years on the road. Imagine a world in which any human driver or human drivers in general had those few crashes, like Ford or General Motors, in a 12-year period. That's not just ordinary care, that's extraordinary care, ladies and gentlemen. Now, Carson Gray may be sympathetic, but the simple fact of the matter is that actions speak a lot louder than words. And you saw the actions that Edison took when it was put on notice, according to, looking right at the timeline, plaintiff's counsel, what they brought up should have put us on notice, right? Let's talk about it. These are all things, first of all, that Darren Ryan brought up. Darren Ryan, a man who was being investigated for HR-related issues, completely unrelated to his work products. A man who would have his own ulterior reasons to go after his boss he's personally feuding with. Now, they did bring up these allegations, and I'll address them substantively. But for now, just consider that part, that you only had in all of this evidence from a company that, if you were to believe the plaintiffs, is apparently a ticking time bomb. No other allegations by no other engineers. Plaintiffs couldn't find any, Edison couldn't find any, the NTSB couldn't find any. So plaintiffs really know better than the federal government? Is that what they are alleging? But as for the substance of these things, you have the 2014 simulation. Particularly, it involved a bike. Now, plaintiffs did point out with their expert, bikes and motorcycles have 2 wheels, so I'll get back to that. The 2014 simulation, they talk about, hey, I think there's an issue with the LiDAR system. You saw it in Darren Ryan's email. Now, you also saw the 6-step process that Dr. Romanoff talked about, that's standard for engineering in general and engineering in this industry. Okay, yeah, maybe there is a problem here, Darren. Let's look into it. Okay, we can't find the cause. Let's see if we can replicate it. We can't replicate it. Okay, then at that point, this isn't a problem. Back to 2017, the Buffalo Niagara incident. Okay, you've raised a problem. Let's look into it. Oh, it's the weather that day. The ice covered up the lane lines. There were 40 other wrecks, and all of them, to the best of our knowledge, were human driven. It had nothing to do with the automated vehicle. That's not a problem. The final allegation, I had to swerve out of the way to avoid hitting a bicycle. Again, a bicycle, not a motorcycle. I'll get to that. Okay, let's look into it. We looked at these tapes. No, Darren, you're over exaggerating. And more importantly, we can't find any other instance of any other engineer in 13 months of road testing who had any similar occurrence. Again, you heard Vincent testify. 99.5% automation rate. Now, again, plaintiffs want to say that that is nowhere near safe enough. It was safe enough for the NTSB. It was safe enough for NHTSA. Are we suddenly being held to a higher standard? We followed all of the laws. There were no issues that were glaring and consistent and repeatable leading up to this incident. Now, as for the day of the incident, let's talk about the vehicle that Mr. Gray was sitting on. Now, first, again, I brought up the motorcycle bicycle distinction. Yes, I think we're all in agreement here. They both have 2 wheels. You guys saw no fewer than 5 times, if my estimates are correct, during this trial, that particular email where Darren Ryan particularly alleges there's an issue with the LiDAR system as it relates to bicycles. So this LiDAR system, right? Light detection and ranging. What does a motorcycle have that a bike would not have? I don't know. An engine's on, so it's probably going to have red brake lights or tail lights. It's going to have reflective paint. It's going to have a reflective license plate. All things that motorcycles absolutely have that bicycles may or may not have. The LiDAR system, that is the closest proximate cause that plaintiffs have alleged, really only speculated about. The same logic doesn't apply, just based on common sense. And as for the most direct proof of the plaintiff having pulled out into the road. Now, counsel just got up and they talked about it was plowed into from behind, directly from behind, and that's how he ended up here. Now, I am no physicist, but they were talking about the weights and the size of the vehicles involved, right? The 3,000-pound large car, say it's like this. If it were to hit, I think we estimated 500-pound motorcycle directly from behind, as plaintiffs are suggesting, plowed right into the spot and not seeing Mr. Gray. Honestly, I'm not sure Mr. Gray would be here right now. He would have gone under that car. Now, him going out into the road, considering the point of impact of a big vehicle coming into its spot while someone else is coming out from behind, that makes far more sense to be ejected to the side and to have admittedly horrible injuries, broken leg, closed head injury, but to still be alive and here. Ladies and gentlemen of the jury, plaintiffs have the burden of proof in terms of the actual proximate cause and damages and breach that happened here today. Don't let counsel, when they get up for their rebuttal, sit down until they have addressed how they can explain this if Edison was the primary cause of negligence here. Now, okay, at this time, I'd like to get into damages. Plaintiff's counsel has already explained the general parts of it, so I'll run through it a bit more quickly. Now, that very first question, based on the facts today, and again, remembering that particular rule I read out, don't let your emotion or bias get in the way. Look at the facts and the evidence. That very first line, Edison Automobile Company, you're gonna write now. And for Carson Gray, you can write yes. You can also write now. Now, we fervently believe that Carson Gray played a role in his own accident. That being the case, we understand that sometimes nobody's at fault. Things are just acts of God. But that very first line, that no, that is not just the more likely explanation. That is the only reasonable explanation. But I wouldn't be doing my job if I didn't cover all the parts. So moving on to question 2. You shouldn't even have to do this, but if you happen to disagree with me, the automotive industry, again, car crashes and car accidents cause a lot of injuries and deaths every year. We're never going to reach perfection. Automated vehicles may make it safer, but it's never going to be 100%. So let's say 10% just de facto because this is a car we're dealing with. 90% to Carson Gray. And finally, damages. Again, I don't think you'll have to deal with this, but I wouldn't be doing my job if we didn't talk about damages, especially as it relates to plaintiff's burden of proof. So that very first line, medical expenses in the past. This is an easy one. It's been stipulated to $125,000. Future medical expenses that a reasonable possibility Carson Gray will incur in the future. Now, we do not deny that Carson Gray will have medical expenses going forward. You heard about his increased Xanax prescription. You heard about him going to the therapist more. But what you weren't able to hear from plaintiff's counsel or from Mr. Gray, because they never actually brought it up, is of that $1,000 a month, how much of that is coming directly from this crash? You heard Mr. Gray testify, he was already going to therapy before. He was already taking all 3 of his prescriptions before. Plaintiff's counsel has a duty to quantify and justify this other than that they happen, they're going to happen, therefore, here's a number. That being said, $10,000. Not going to deny they don't exist, but there's simply no concrete connection between what counsel argued and what the facts suggest. Physical pain and suffering in the past, again. Counsel didn't really justify the quantification, but you heard that Mr. Gray did have to relearn how to walk. It took him 7 months, and for those 7 months, you can only assume he was experiencing extreme pain in his legs. $1,000 a month times 7 months, $7,000. Physical pain and suffering that a reasonable probability Carson Gray will sustain in the future. Now you heard Mr. Gray say he's occasionally sore from time to time, occasionally walks with a limp, but you also heard he still gets to ride his motorcycle, that 500-pound motorcycle. He still gets to do his job to his full ability, it's a desk job, still gets to hang out with his friends. Counsel, again, did not meet their burden at all. They didn't suggest any evidence other than here's a big number and he's gonna live a long time, 0. Mental anguish sustained in the past. Again, a number that can't be quantified, but we don't deny that this man has suffered. $1,000 for every 5 years that this has been litigated. That's, sorry, for every year this has been litigated, 5 years, $5,000. Mental anguish and reasonable probability Carson Gray will sustain in the future. This is the same thing with medical damages, the most understandable damages. Or bills, excuse me, that Mr. Gray will have to pay moving forward relates to his mental health. It hasn't been quantified, but we don't deny it happened. $1,000. Physical impairment sustained in the past. This is the same as what was argued with his physical pain and suffering, because it had to do with his legs. So again, $7,000, $1,000 for each month he was unable to walk without the aid of any walker, cane, wheelchair. Physical impairment and reasonable probability Carson Gray will sustain in the future. I already got into this in one of the earlier examples, especially with the pain and suffering in the future. Mr. Gray is still able to do exactly what he loves, ride that 500-pound motorcycle, still able to do his full job, still able to partake in most of his hobbies, I would assume. I don't know, because we didn't hear from plaintiff. $0. Disfigurement sustained in the past. Mr. Gray did, we assume, have casts again for that 7-month period. We did not hear much beyond that. $1,000 for all 7 months he was in physical therapy, $7,000. Disfigurement that in reasonable probability Carson Gray will sustain in the future. I know counsel put out a big number. I also, looking at Mr. Gray, I see his suffering, but I don't see any physical disfigurement. Counsel hasn't really proven what that is and how you can even quantify that, $0. Lost wages incurred in the past. Now, counsel did throw out a particularly large number citing potential lost promotions and overtime. Again, those are just speculation. What we can agree on is that Carson Gray in his 6 months of work, he made $4,000 a month. $4,000 times 6 months, $24,000. Ladies and gentlemen, these are the reasonable numbers based on the preponderance of the evidence. But again, you don't even have to do them. If you look back to exactly what we said at the beginning, I said at the beginning of my closing, and I'm going to say again now. 2 competing explanations. What's more likely? It may hurt, it may be ugly. It may seem even unfair. That unfairness is not the result of Edison automobiles. Plaintiffs have failed to make their case. That is not Carson Gray's fault. That's not our fault. That is counsel's fault. Again, we ask that you find what the evidence suggests and justice demands. Don't halt innovation and safety out of sympathy. Find Edison automobiles not liable. Thank you.
Thank you, Ms. Mahoney. Ms. Lawrence, any final thoughts?
Yes, sir. Wrong place, wrong time. Carson Gray certainly was. Now, all of you opposing counsel, these numbers can't be quantified. That's the point. You can't measure with exact hard numbers how much pain is worth, how much suffering is worth, how much your entire life being up in you is worth. This is the system we have. to hold companies like Edison liable. Now, I agree, Ms. Sin has a right to defend her company. But if she's so set on defending her company, why is she dodging my co-counsel's questions? Why can't she take ownership over the 3 events that showed that her vehicles were having problems? Excuses after excuses, icy roads, personal vendettas, emails sent at 3 a.m. Don't let us get away with these excuses.
Thank you very much. We've now heard all the evidence. We've heard the closing arguments of the lawyers. It's time for the jury to deliberate and reach a verdict. You will, do we stay in the courtroom or do the parties stay in the courtroom?
The parties leave.
I think that's a good idea.
Or mobile.
I think the parties should leave and we will call you back in here in just a few minutes. Okay, well, I think that first off, y'all should notice that you must not have been exciting the spectators too much because except for the judges, they all hauled at halftime and took off. Okay, I don't know.
Competitors, they were.
I know that. I don't know.
Okay.
I don't know if you noticed that, but the entertainment value of this, never mind. Okay, I'm gonna go first. Mr. Krumpholz, you started off in opening arguing your case. You know, some people would object to it, some wouldn't. But one thing that you did, and I don't know if you did it intentionally or not, but you paced back and forth. You went up to the jury, then you went back, and you did this several times. Whenever you went up, you were describing the scene, and when you went back into your opening statement. Now, I don't know if it was planned that way or if it's nervous energy or what. If it's planned that way, it's interesting, but if you move around too much, I think it's distracting and it might distract the jury's attention away from you. But it's a strategic thing that did you notice you were doing that?
I did not, Your Honor.
Okay.
It's just been unintentional.
All right, well, you know, if it's intentional, I get it because you're doing this signposting thing. When you're here, you're doing this. When you're here, you're doing that. So, you know, for what it's worth, I noticed it. Anybody else notice it? Yeah.
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 The one part though I did find effective was kind of the reenactment a little bit. I do enjoy a little bit of flair, but I agree with what you're saying. You then kind of go back to something.
Especially if it's unintentional.
Move. I mean, you got the whole well. You don't have to be on this track back and forth.
Yeah, but it was a sort of thing. When you're directing the plaintiff, do more to tell the jury who the plaintiff is. You're going to ask these people for $12 million and they have to feel for the plaintiff. Now, in a mock trial competition, that's hard to do because your clock is working against you, which it did against y'all. When you're going to use a demonstrative, I think you come in with a ready-made demonstrative instead of drawing on a sheet of paper because it's not as neat, it's not as clear. And what you did with Carson Gray is you set up the scene and described the scene, and then you went through it again on the demonstrative, and you were drawing on the demonstrative as opposed to Carson Gray coming down and showing where he was on the demonstrative. I say put that all in one series of questions and have a neat demonstrative already built. Now, I know this is mock trial and you're not going to spend a lot of money on this stuff. Make her pay for it, for crying out loud. Okay, and look, if you think I'm picking on one person, I'm really not, because y'all can all learn from it. Let's see. One of y'all used the acronym MIL, and then you did it again. And don't use acronyms in front of the jury. The jury doesn't live your case. And if you do that, I'm going to say, I'm sorry, what does that mean? Even though I know what an MIL is, I've been doing this for a couple of years, but don't use acronyms. You didn't do this, but don't go Rule 403, Judge. State what it is you want and describe it. And if it's Rule 403, you describe what the rule says and don't act so familiar with stuff that they're wondering, what in the world are you talking about? If you're going to use math, you got to know what your math says. You can't be guessing yourself. What's 1% of 100,000? You know that walking up there. When you're going to play math, and you played the dumbest mathematician known to humankind, which is really interesting for a CEO of a major automotive company to say, I don't know what 1% is, or 0.5%. That's kind of interesting. It was strange. But if you're the one, and all of y'all know this, if you're going to do math, you have your math ready. You don't say, well, let me think about this. I don't have my calculator. What is 1% of 100? You got to have it. And you hit them on it and use it. The math thing is not such a terrible thing. To say there were 500 instances where something bad happened, that's a good thing for you, but you have to have that number in your head. Objection, non-responsive. Y'all were really good on objections. In other words, you didn't make many. Okay, that's a good thing. That's a good thing because there wasn't a whole lot of stuff to be objected to. So that's good. I don't think you win your case in objections, and you will not get a case reversed on objections. Anybody disagree with that over there?
I think in real life, that's true,
And
but for mock trial.
For mock trial, you have to recognize that you know what the rules are, but there wasn't a whole lot of objectionable stuff here. But if you make an objection, decide whether you want a ruling. Objection, non-responsive. 95% of the non-responsive objections in the courtroom are ignored by the objector, and they move on to the next question. I don't care if I get a ruling or not. Now, you may be doing that because all you want to do is let the jury know that wasn't the answer that I was looking for, and you move on. If you really actually want a ruling, you got to wait, take a breath so the court can make a ruling. I don't, as a practitioner, I didn't make a non-responsive objection until I said, Ms. Mahoney, what color is the sky? Well, you know, that's a hard thing to say because, no, hold on a second. I understand that's your answer to the question, but it's really a simple question. And I do that a couple of times. And then when I don't get an answer, because now they realize that you're being a jerk. And then I say, Judge, I have to object non-responsive. And then everybody in the room understands what's going on. I think it was Ms. Nuenke. When Romanoff got up, who's expert? You did Romanoff, right? You got up and did something I did as a mock trial competitor and as a practitioner. You got up without asking anybody for anything and moved the easel out of the way. Perfect move. Once it's your turn, you can get that thing out of the way because you don't want it up there while you're talking to the witness. It's your time, and I don't have a problem at all with you getting up and moving the darn thing out of the way. I thought that was very effective. And the last comment I'm going to make is you both did this very, very well. On closing argument, you never, ever, ever sit down without telling the jury what you want them to do on the jury charge and go through it completely. Because on the plaintiff side, if you don't fully open, and fully open means you give them the answers to every question on the charge. If you don't fully open, you don't get to talk about it on your rebuttal. Half the lawyers that come into this court and try cases don't realize that. And I've had several lawyers in real trials not do that, and the defense never objected to it on rebuttal, because if they had, it's sustained. That's the rule, and it's very obvious. And you defense lawyers over there probably know it and are keeping track of it. I'm not looking at you, McLeod.
Oh, I know.
And so you guys did an excellent job on that. I commend you. And one other thing, come up anytime, folks. You guys did a really, really good job of putting the case on. When you go to do it in real life, take what you're learning here and run with it, because you're learning good skills. And I gotta tell you something, half the lawyers or more that try cases in my court aren't nearly as good as you guys are. So thank you.
Thank
Yeah,
you.
thank you.
I'm just gonna be real quick. I've got to run to the hospital. But what I want to say, Judge Schaffer treated y'all exactly like he treats every lawyer that comes to his courtroom. He's seriously, I mean, we always joke, he calls balls and strikes. So he's like, ma'am, is it hearsay? Or do you see hearsay? And literally, I love that because you're getting a real feel. I thought y'all did an excellent job. I know that some of y'all are 2Ls, and I think that is incredible. I think that is so awesome. I was impressed. I echo a lot of the comments that were made. You know, as a plaintiff's lawyer, you know, when you tell me 125,000 opening, you better tell me early and often millions, because I want to hear millions and millions. And I don't just say, I'll give them a number. I'll say, look, I'm going to ask y'all for 12 million. Here's why. Because otherwise you get kind of shocked at the end when you start hearing all those numbers. And I thought some things, you know, on the defense side, your closing, you said, you know, he went through extreme pain. I would never admit that. I love that you were apologetic. And I thought you did a really good job of being a defense closing. Defense closing is not easy when you got a person with real injuries. When you got real injuries, it's a hard, you know, it's a hard line. But I thought y'all did excellent. I would love to give y'all more individual comments. I'm going to send them to Judge Weems because I've got them and I want you to have them. But I love that y'all are doing this. I know it takes a lot of time. You should be very proud of yourselves. Very. Thank you.
Hey guys, my name's Mia. I'll do comments really quick. So I do commercial litigation at law court, so mainly defense work. And so one of the things that Ryan's talking about is that when you're asking for that amount of money, the jury needs to know upfront. Because I had no like ballpark until I heard the 125,000, and I'm like, oh, are we talking about like a total of 300,000? And so then to hear 12 million at the end was kind of like, whoa. In the opening, Jeff, I thought you did a really good job of setting the scene. I think that's always the plaintiff's job to kind of put things in perspective. What are we looking at? But then like you got through the whole story and you were like, okay, now Carson's in the hospital and we'll get back to him being in the hospital. And that's honestly like the most important part. It felt like you like gave us a commercial break in the middle of this movie that was like rolling. And so now I know he's in the hospital. I don't really know for what, but by the time you get back to it, like the impact of that has worn off. I'm like, oh, well, I heard he was in the hospital. You took this detour. So just kind of think about when you're setting up your opening story and how you want this to be portrayed to the jury. What is really important and what do you want to get out as you're giving that story without giving the breaks in there? Hayleigh, I liked your opening. I wanted to hear a little bit more. So I don't know if you guys had the facts for this, and I know you're not going to try this case again, but some of the questions that I had were, you know, was Carson breaking any laws because he was sitting on a running motorcycle without a license? Was he breaking any laws because he didn't have on a helmet? Why did he try to jump off the motorcycle? How fast was the car going before it struck the motorcycle? Those were just some of the questions. Were there any other parked cars on the street? These are, I don't know that you could have answered them, but that's kind of where I was going while you guys were trying the case.
And a lot of that stuff will be on the electronic data recorder in the vehicle. And so you'll do discovery on that, which will tell you more about where the car was at the time of the crash.
But defense lawyers and all these details.
It's called, it's called smoke.
Exactly. I've seen it.
Paige, you had a good response when Judge Schaffer asked you about hearsay. It was just very fast. Like, I think you were very confident, which is good, but I think it was really fast to slow down a little bit. There were several times where an advocate would be talking about an exhibit, an email, a demonstrative, and you have to remember that everything that you're saying is being typed down. It's not being video recorded. And so if there's a potential appeal, we're looking at a transcript. So when you refer to an exhibit as this, that, over there, here, that's not going to read on your transcript. So you want to remember that if you're talking about exhibit B, you're saying page 1 of exhibit B, or if you're talking about demonstrative 1, D1 on the bottom half of the page on the right side, just so you have a clean record for your appeal, okay? And then closings, I think I mentioned the 12 million was kind of a shock on the defense side. I would never, ever say like, oh, we know this was horrible. Now, I do appreciate, Gracie, that you were the first person on the defense side that acknowledged that the plaintiff suffered some injury. So I will say that was good. If you're talking to your witness and you're prepping your witness ahead of time, you want your CEO to have some sympathy. Like, we get that she's like, this isn't our fault, but you do want her to acknowledge, like, yes, what happened is bad, but that doesn't make it our fault. So I thought you guys did an excellent job. Very impressed.
Casey, defense lawyer as well. I'll do my critique slightly differently, because I echo everything everybody else said wholeheartedly. Favorite moment of the trial was the defense expert and the demonstrative that you guys made. That was very, very, very good, very persuasive. I was able to follow that and went down with it. Least favorite moment. I don't know who I hated more, you or you during that.
Wait, who is you or you? I can't see you pointing.
They're like raising their hands, they're like,
Oh.
yeah.
Madam Smug?
Yeah, y'all were smart.
Witness, you can't ever say, oh, I wasn't asked that, and not trial again, and you'll learn that.
She'll yell at you about that. She being me.
Yeah, but like, lawyer, you gotta understand that, like, you gotta understand how we see it, and like, you're being that aggressive to the little lady on the stand, like, we hate you. So don't do that, y'all. Like, actually, so kind of like what Michelle Obama said, you know, when they go low, we go high, and mock trial, and in real trial, when you guys act like a jerk, that's your opportunity to gain some serious points. So keep that in mind. You never, ever, ever win by being, oh, you do it now. Yeah, I'm gonna get some points to everybody. Drink some coffee. You're hurt. You gotta be excited. You're asking us for $12 million. Paige, you too. Like, if you're gonna ask for 12 million, I mean, you need to be like, I need to be ready to sign it up at the end. You know, that's a lot of money. Gracie, great job. I loved your closing. Did you come to the podium? One of y'all did not come to the podium.
That's me. I like the Texas rule of sitting, but everybody was gonna stand. I didn't want to make them feel weird, so I was like, I'm just gonna go from counsel's table. But-
No.
And for mock trial, you think the podium's better? But
Well, I mean, if everybody else is doing it, I was just
I
like,
just kind of got copy.
yeah.
That's fair.
So, opening is very good. Hayleigh, slow down.
Okay.
Yeah, I felt real rushed. Otherwise, great job. John Henry, you're fabulous. And every witness, so you want to put your name.
Mike.
Mike.
Mike, you're my favorite.
Thank you.
I will say I would have objected to
Yeah.
his reconstruction. That would be one objection. I do think Judge might have an appellate issue.
It is so hard. It is so hard to get a case overturned because of the failure to make an objection or even to make an objection, because ultimately it has to lead to an improper verdict. And I will tell you, in 13 years on the bench, almost 14, that is, those issues haven't hardly ever been raised in anything out of my court. That could be because I ruled correctly on objections, but I doubt it. But, you know, I just a couple of weeks ago had a case come up where I thought an objection on a piece of evidence might be one that would result in a potential reversal. But that's why I say that even with that, it still has to result in the rendition of an improper verdict.
I will say this briefly on a side note on that whole stage. Y'all ain't worried about appeal at this level. What you're worried about is showing the judges that you know. And from what I saw, I was like, oh my God, there are so many objections that, and I'll say just so that you have an understanding of why I tried this case. And when I mean I tried this case, I coached this AAJ team. This is the tournament problem for AAJ that literally happened right before COVID. They canceled the tournament the night before the tournament was supposed to happen. So the weekend before, as their coach, I sparred against the team, both of the AAJ teams, to get them ready. This case is an evidentiary battle. And that's what I would love to have seen here, and I would have loved to have seen more of. There are a lot more objections, and I don't know if y'all were just objecting. It's like, part of me's like, oh my God, do we try to teach them to be too nice? Is that what it is? Or like, are they not objecting because they're trying to be nice? Or they're not objecting because they're not sure what the objections are? You'll get there, I promise you. But what I mean by that, as opposed to from the appellate standpoint, is that if I were judging this, I'm not saying necessarily that I would dock points from you for like, oh, they missed a bunch of objections. But when I'm looking at ranking y'all at the end of the day, regardless of points, it would be so-and-so missed 10 objections. That this person seemed a little bit sharper on it, so they get ranked a little higher. You know, because when I'm looking at awarding things like little gold plated fuckos, that, you know, that's literally only based off of the ranking, not the score. So you could score higher, and that happened a lot during this tournament, where people scored higher but were ranked lower. And that's the impression. And that's kind of what you should always remember. I know we talked about this in boot camp. But remember about every aspect of this, of what you're doing here. Now that you've kind of gone through a tournament, you get the feel for it. We don't have a checklist. None of the judges have a checklist like this is what a 10 looks like, this is what a 5 looks like. It's literally based on, after we saw what you just did, how do we feel about you? Overall, how did that make us feel? Did that feel like a 9? Did that feel like a 5? Did that feel like a 7? You know? So just be mindful of that. The objections are going to come. We're going to teach you that. But just know that that was for me the only thing I was missing this round. I would have loved to have seen a little bit more fight in you in that regard. All right. And I, like I said, I don't know if y'all are objectors, you weren't comfortable. I know half y'all aren't taking evidence yet, but it'll come and you'll love it. And it'll be a crap ton of fun when you start battling objections. So any other feedback from all of you wonderful, talented, smart people who came here to judge them? Love you, hearts.
The podium thing, I don't care about that. Do it wherever you feel comfortable from. I would prefer seeing you at the desk, but some people like the podium. I just don't let you wander around. And which the more higher profile lawyers love to wander around. And I have told Rusty Harden to get back to the table. I've told John Zabatsanos to get back to the podium. And I've told people that they're not going to, you know, play the role of the wandering Jew. It's just not going to happen. You're going to return to your either the table or the podium. If you like the podium, bring the podium out so that it's in that space, because you're not on top of one of the jurors. Or stay at the table or stand at the table, but it doesn't matter to me which one you use. And I don't think in the long run, it'll matter to many folks as long as you're consistent, that's all.
Only in the state of Texas. I'm going to caveat that right here. When you travel outside the state of Texas, they will never sit. They think it's weird that we sit at council table for direct and crosses. So you will never do that when you travel, and almost all of our tournaments are out of state this semester. You always use a podium, and you'll follow the federal rule where you will stay 1 arm's length of the podium at all times unless a judge gives you freedom of the will. Right?
The moral of that is ask. At the
No, but that's
beginning,
true, you're right.
at the beginning, no, at the beginning, ask. Don't wait till halfway through the trial.
Because you, right, because it's a matter of preference. Whereas, and I totally get what Judge Schaffer's saying. Because I teach y'all, I told them wander around. And Rusty Hart was just like literally having a field day all over my courtroom when he was in trial here for a month. I don't care. It's not my dog. I'm letting they put on. I have to put on whatever dog and pony show they want as long as they do not get too close to the jury. So you just have to find out the preference of your judge. Always ask, especially if you ask at the beginning. Once you know, great. You know what the rules of that court is, and it will change from round to round to round. All right.
Good job, yeah.
In real, one last comment, in real life, the judge wants to control, at least this judge wants to control what's going on in the courtroom. So it doesn't degenerate into something you can't control afterwards. And so that's why I'm a little more controlling than she is.
But I have also not been on the bench for 13 years. Not to make an age joke, but you know.
She'll change. Thank y'all.
All right. Wait, we need to take a picture. Can we take a picture real quick? before you leave?
Absolutely.
You're about to
I'm
leave.
not leaving.
Let's take a picture quick, and then we'll take a picture of both teams and the judges before we announce winners. John, man, Ryan,
Where do you want me to, where do you want me?
I don't know, who's got a camera? I have my camera on my chambers.
Casey, are you on?
Hey, can one of you coaches take a picture? Everybody come up to the front.
You want me to stay here or come down?
Calm down.
I'm glad to.
No, it's gonna be lording over everybody. Take it on yours. Yeah. All right, y'all get in. I'll check it too. Everybody. I'm gonna get.
You're a little,
Already, yeah, we need to come, we need to do like 2 levels. Y'all are too far. Too deep. Too deep. Too deep. There we go.
all right, on the count of 3. 1, 2, 3. And now I'm just doing it. Got it.
All right, let me award little plastic statues and gift certificates and so
Thank you, guys.
I'm gonna say this first because
I'm serious. Y'all are all welcome here.
Thank you so much.
And if you want to come just watch, I don't care what Wayne's told you. You don't have to have permission. You just come on by.
what am I saying? I'm open court.
She's probably, she doesn't know what open courts is.
Oh man, you ready to go? What are you doing?
Yes, Wayne for inviting me.
Thank you, Judge Schaffer, for being here. Goodness gracious. All right, so I have. They're literally labeled with finals so that they differentiated from the first ones. Because I care. They're a little bit less tacky than the ones from earlier because they've dried out a little bit more. Somewhere in this building are gavels. I ordered 4 gavels for the championship team and they got lost. So they're here. The winning team will get them later. We literally tried to break into everything. Oh God, we're still recording. They tried to go into every room you could get access to get there. And then these are 4 gift cards, literally with instructions on who the winning team members need to reach out Tom James to make an appointment to literally be custom fitted for your suit, 2 shirts, and either 2 ties or like $100 to get scarves. I don't know how expensive the scarves are, but that's what I was told, $100 for scarves. So no, this is very, very exciting. And I only take a quick moment of personal privilege because the very first year we did BLG, the first year I took over this job, it was all over Zoom. I had 0 budget, no sponsors, and the winners literally, I printed out certificates that I color printed and bought dollar store frames, and that's what you got for winning. All right, we've moved up. In only 3 years, we've moved up a lot. So I'm gonna start with this is the witness award. The witness award, the outstanding witness in the final lane goes to Dinella.
Dr. Romanoff.
Congratulations. Oh, you get a picture.
I wasn't sure if they're doing
Yeah,
it.
we already got the picture. Somebody with the camera take a picture. Because I don't have mine. We like photos.
We'll get judged in the background.
Reaper, get a photo.
2, 3.
You know, photo bomb action.
You bet.
You bet.
So let me tell you why I'm really excited about this, and that's just because this is not an easy choice. That's what I love was the fact that it wasn't like one attorney won all the ballots. It was like all over the place for all 4 of y'all, which means that we're doing something right as a program that, and we knew we talked to you about this at some point. It comes down to personal preference, right? If you guys are all good, then winning things like awards for individual achievement literally come down to personal preference. So I'm proud of all 4 of you. But the one who takes this little bubbly head guy home is Gracie. Come, put it in there. Somebody gets up. I don't have a camera. My camera's back there. Right back there. My camera's
1, 2, 3. Got it.
So y'all might have figured out. Congratulations, y'all. Top 4. Oh my gosh, top 4. Yep, y'all on the final. Congratulations.